Okay.
All right,
Same.
board is now in session.
You all can be seated. Good morning, everyone. Morning.
Bring it out there. That's how we do it. Okay, I would say.
As far as you know, the feed is working. Excellent, thank you. Court reporter's here and happy and ready to go.
So it's this above. Yeah.
All right, Mr. Chamberlain, are we able to get started?
Well, we're trying to work out this exhibit issue.
Okay. If you could take a seat with counsel and if Ms. Veal could take a seat. If you get more time, you may be able to work more out. We need to get started. It is the 29th. We had a conference with the lawyers right at 9, worked through a couple of issues, and I think we are ready to pick up where we left off yesterday. The director had called what she thought would be her last witness. Then we had a number of matters to take up with just the lawyers. And at the very end of the day, Ms. Veal had asked to have the evening to work through whether there would be any additional presentation from the director in what I'll call the director's case in chief. I mean, there couldn't be rebuttal later, but whether the director was prepared to rest at this time. Your announcement is?
Your Honor, I have a few things I'd like to put on the record regarding the exhibits that were tendered during the director's presentation.
Just yesterday or throughout the course of the presentation?
Throughout the course of the presentation.
Okay.
As we were reviewing the transcripts from the first 4 days of the hearing, we noted that there were some exhibits that had been noted by the court reporter as being stipulated to, but it was not noted that they were admitted. So I just want to make sure the record is clear. I'm going to start with exhibit number 14. That was the courthouse security video. We stipulated to the admissibility of that exhibit, and I just want to ensure that the record is clear that was admitted.
Sure. To streamline, I have exhibits 1 through 48 all having been admitted, some by stipulation, there may have been an objection, but that was overruled, or there was no objection. But I have 1 through 48 all admitted. I don't have 49 having been admitted. That's the town hall meeting minutes.
Your Honor, I'm going to withdraw exhibit 49.
Okay, then it remains not admitted. And then 50 through 59 were all admitted. I don't think there were any stipulations in there. There were some objections, all of which are preserved, but 51 through 59 were all admitted. My notes are less good when we get to 61 through 74 because those are handwritten. Your chart ends with 60. 60 was not admitted. That's simply a calendar for April of 2021. Happy to take judicial notice of the month of April 2021 if we need to when we're coming up with our report and recommendation.
If you would, please.
Okay.
Thank you.
that month did exist.
What did you say about 61?
Well, from 61 onward, it's handwritten, but I've got 61 through 64 all admitted. No objection to the first three. There was an objection relevance to number 64, an email from Ms. Mercado, but it was admitted. And then for 65 onward, I have them written down, but I don't have whether they were admitted or not. So I don't mean to make that murky. I just sort of ran out of space.
So I have 65 and 66 were both admitted. There was no objection to either one.
Okay, a screenshot of Cube ACR and the transcript of the call with Captain Wilson.
That's correct.
Okay.
67 is the recording between Captain Wilson and Judge Peterson. That was played through Judge Peterson. I do not have that it was admitted though. So if I did not move to admit that, then I moved to admit it now. And again, it was already played through her.
Okay. Any objection, Mr. Tate, to the admission, if it hasn't been, of 67, a recording of a phone call between Judge Peterson and Captain Wilson concerning access to the courthouse?
Objection.
Okay, it's admitted.
68 was the string of emails that were provided by Judge Peterson to her counsel that came out during the course of her testimony. I ended up asking her some questions about those emails, and I moved to admit them, but I do not have, the record does not show that they were admitted.
So what about 69? Because this all relates to emails and Ms. Mercado and that, because let's just deal with them together.
Sure. So again, 68 was the string of emails that Judge Peterson produced to her counsel. That's this set.
Okay.
And then I asked her questions about those and moved to admit them. I thought if I did not, I want to make sure that they're admitted.
Okay.
69 is the email that I have and disclosed in discovery.
That was not included in 68. Okay. Mr. Tate, 68, any objection to the admission of Director 68, which is sort of, it's not your 68 in that you didn't tender it, but you provided it to Ms. Veal. Okay, and then 69, I think, was admitted.
And I want to be clear, Your Honor asked me if it was not, if it was part of discovery. So the 69 is something I obtained during the course of our investigation, and I did disclose this to the respondent hearing.
Okay, I didn't ask it artfully. What I meant was, as I'm recalling, for whatever reason, 69 was not part of the universe of 68.
That's
Got it. Okay, and then 70 was I have written down here, defendant's timeline.
That 70 is the Excel spreadsheet timeline that Judge Peterson created and provided to her counsel. And it was given to me during the course of the hearing. I asked her questions about it, and I want to make sure that 70 was admitted.
Or at least is made part of the record, since you were asking a witness about it.
I do know that there was not an objection.
Okay. Any 70? Okay, well, if it wasn't before, it's admitted now. And then I jumped to 73. I don't have a 71 and 72. I think that's where Mr. Lopez pointed out you had marked some as 71 and 72. We didn't use them. 73 is the 2022 homeowners association suit, not the older one, but the newer one. And that was admitted. And then the order dismissing that 2021 suit is 74, and that was also admitted.
That's correct.
And that's as high as I got with the numbers.
And that's where my numbers conclude. 71 and 72 were 17C letters that came up during the course of Judge Peterson's examination. I attempted to tender those letters and they were objected to, and I don't believe Your Honor admitted those letters at the time.
Okay.
I will note that on the respondent exhibit list that I received yesterday, there are some 17C letters on there. And perhaps we need to explore whether there's been a change in the respondent's position regarding whether they want those letters.
Okay. All right, but in terms of what you thought you had tendered and had been admitted or should have been admitted or was meant to be admitted, I think we've covered it now.
That is correct.
Okay. Anything else you want to discuss before you rest?
No, Your Honor, and at this time, the direct arrests.
Okay. What would happen if we had an infinite amount of time? Next would be we take a break and come back and hear motions for directed verdict from Judge Peterson's team. Mr. Chamberlain has already shared with us a motion that addresses directed verdict for some of the counts that are somewhat contingent on First Amendment rights. So that argument has been made. All other arguments are preserved. Nothing is waived, but I'm going to ask, as we previewed last night, that we actually step right into any presentation that Judge Peterson wants to make through her lawyers, preserving 100% any and all directed verdict arguments to include any amplifications on the 30-page brief that relates to First Amendment bases for directed verdict for a handful of the remaining 30 counts.
We're ready to proceed, Your Honor.
Okay. Anything more you want on the record about preserving your rights about directed?
We're subject to the agreement and the direction of the council. We do move for directed verdict on all counts contained in the complaint.
Okay.
Nothing other than that.
Got it. And we will reach that issue, but what we will do now is ask you, Mr. Tate, to call your first witness, or Mr. Chamberlain.
Yes.
Morning.
At this time, we would call back to stand Judge Peterson.
Great. Judge Peterson, please.
Judge, a point of procedure, since I've not appeared before you before, should there be any concern about not admitting certain evidence, would you like me to make the proffer after the conclusion of the witness or during break?
When you say the proffer, I guess what we'll do
in other
is,
words, yeah, you understand, if you were, and I'm not saying you would, but if you should decide, or the panel decides to rule with the JQC and say a certain exhibit is not allowed to preserve the record, I want to make a proffer.
got it. So we have a couple of ways of handling that. Both would happen when you're done with your examination of Judge Peterson. You'll just need to remember.
I understand.
Hey, there were a few exhibits that you excluded, but I do want to get into the record what those exhibits would have been, whether it's through a proffer or we admit them into the record for appellate purposes, but they aren't part of what we consider as the evidentiary record.
I understand. I didn't know how you wanted to handle that, and that's fine. So I'll do it after I'm done with her.
Great.
Okay, very good.
One other thing, before we have our bailiff swear in Judge Peterson, she did testify for many hours before, and it's important that you do your best to make sure that you're exploring new areas. I appreciate that there will be some overlap. You may ask her to say her name again, for example, and that's fine. But if there were areas that Mr. Tate explored with Judge Peterson, we ought not to dwell on them all that extensively because we've already heard a whole bunch. It's not to preclude you from presenting what you want to, but if it becomes too duplicative, one of us up here may say, let's go to a different topic.
I understand. I appreciate that. And
Sure.
to that point, that was another point of procedure I wanted to address with the court. When I begin her examination, I intend to lead her in the very beginning to get to the very narrow area that I wish clarification for. And that will require me to lead her quite a bit so we don't waste a lot of time, so I can get to the point I want to examine her on.
Okay, that's good to know. Ms. Veal will handle those questions as she sees fit, but maybe she'll give you a little leeway if it seems like you're simply getting folks focused.
Right.
Okay. All
Very
right.
good.
Can we swear the witness in?
Absolutely, I do.
Good morning, Judge.
Good morning.
As you heard, briefly, we are going to try to focus on certain aspects of your testimony. We're not going to, re-plow fields that have already been plowed previously in prior testimony. So let us try to confine ourselves narrowly to the various issues that I'll address with you now. Okay.
Okay.
All right. What I would first like to turn the panel's attention to concerns the wedding party incident. Specifically, I'd like to turn to the charges raised by count 19, which was charging you, Judge, with violating Rule 1.2B, which was maintaining standards that would promote and preserve independence, impartiality, independence. That count also charged you with violation of Rule 2.5, which was addressing performing administrative responsibilities competently without bias or prejudice.
Okay.
So as concerning that particular charge, that's what I want to focus you in on.
Okay.
As a further preface, you remember that your previous testimony regarding your decision to call Sheriff Pounds when you were dealing with the wedding on the day in question. You remember your testimony concerning your decision to call Sheriff Pounds. Is that correct?
Absolutely.
All right. And it is also to focus you. You made that decision after you understood from, I guess it was Sheriff Trent Wilson, that he did not want you to go in.
Yes, correct. Prior
Right.
to coming. Yes.
Okay. So that is the narrow focus that I want right now.
Okay.
My question is this. Can you please tell the panel what information or event occurred to you that motivated you or prompted you to call Sheriff Pounds and question what Sheriff Wilson had told you?
Well, after I spoke to Sheriff Wilson, I'm at my house, or Deputy Captain Wilson at my house. Then I got to the courthouse. I was okay with having the wedding outside. I talked to the party. It was a Hispanic couple with their 2 Hispanic children. The oldest daughter was interpreting. So I asked her, are they okay with having it outside? They said, no problem. But while we were sitting out there, we saw a wedding party go in, and that was a African couple with all of their family members. And then the little girl said, why, my mother is asking, why are we not able to go inside? Why are we being treated differently? Because they could recognize that it was a wedding because there was a limo outside and they had on wedding gowns and all the beautiful African attire. So I said, agreed. So I called the sheriff.
Let me stop you. So why was that significant? How did that affect you and cause you to feel that you had to call Sheriff Pounds?
Well, but even not being a judge, I want everybody to be treated right. You want people to be treated fairly. And I just didn't want her to feel like she expressed in that moment that she was feeling that she was being in essence discriminated or treated in a bias. So I just went over Captain Wilson's head, and I know who the sheriff is. I've been knowing the sheriff since 2016. I have his cell phone number, picked up the phone and called him. So that's what prompted me to call the sheriff and get his permission.
And you did call Sheriff Clayton based upon your previous testimony?
Sheriff Pounds.
I'm sorry. I
don't think Clayton wants to run.
You called Sheriff Pounds.
Right.
And your understanding from him was what?
Sheriff told me it's secure. I said, well, I talked to Trent Wilson earlier. He said I couldn't go. But you have a deputy here. He said, well, it's secure. My sheriff deputy is there. You can have your wedding, go inside. I went inside and did the wedding. Deputy Clayton was there. So I didn't know his name at the time, but we went in, he did his wedding. I did my wedding. He walked his people out. I walked my people out. He closed the doors and that was it.
Judge Peterson, can I ask you, how old was the little girl that was?
She had to be about 11.
she interpreted the entire ceremony?
No, I did the ceremony in Spanish.
Okay.
So I have a wedding book that was left by Hamrick. Thank you, Judge Hamrick. But this book had a Spanish script, and I studied Spanish so I can read in Spanish. So that was the only one I've done in Spanish.
Thank you.
Comment you made about the young girl.
Yes.
If you mentioned that to the investigative panel or the investigators of the commission.
Did I talk? I don't, let me see. Did I talk? You know, I don't think nobody's asked. I like during the investigation, the whole investigation, I think it was just you're guilty. It wasn't a let me know what happened. So I don't think I was ever asked, honestly.
So that precluded you from saying something that might be probative to the panel.
Well, I've always tried to say something, but I have counsel, and my counsel does a good job of contacting the JQC and saying, and trying to get with them and tell them what happened. I think we wrote out, actually, we did. We wrote it on we did a written statement, and I stated that. Yeah, so yeah, I stated all of these things, and even actually then Alfred, I think that's his name, I'm not sure, but he actually came to my office as well, and I shared this information with him when he came to my office.
May I proceed?
Yes, sir.
Thank you. So in your judgment, allowing your wedding party to go into the courtroom on that day,
Courthouse, yeah.
the courthouse, how does that comport with your understanding of rules 1.2B and 2.5 with which you are charged in count 19?
I would have thought if I didn't try to rectify the situation, that I would have been violating that rule, those rules. There's no way to explain to any member of my community why one party was allowed and one party wasn't. I don't know, it's not on the basis of color or race. It could be basis on the sheriff is allowing his people in and civilians are not. That's not fair. It's a bias. So I feel like in order to facilitate the impartiality, we should allow, if they're allowing it, it should be allowed for me. And that's why I called the sheriff and he allowed it.
Thank you. Now, as a result of your actions, the event that occurred later affected a particular right concerning your access to the courthouse, which we've covered, correct?
Yes.
And that was a right, just to bring us to where I want to be, concerning your right to the courthouse being restricted.
Right.
You were locked out of the courthouse.
I was.
Yes. And did you come to learn who was
I'm
the?
gonna pause you for one
Yeah.
second, because I guess I'm not remembering it correctly.
Sure.
Judge Peterson, my recollection was that a decision was made to restrict your after hours access. Was it actually you had no access, that if you showed up at 10 in the morning on a Tuesday, you could not get in the building?
Well, I didn't have no one was talking to me. Remember, I didn't have conversation with anybody. I just know when I went, I couldn't access. I didn't know if it was after hours or so. Later in an email, days later, it was said after hours, but I knew anytime I went to the back door, I didn't have access.
Did you go to the back door during 20 hours of 9 to 5?
On a week, no, I had a training, so I was going over the weekend. And so we accessed the courthouse through a back door, and that's when I knew. So I didn't go during the day.
You only tried to use this entry card when you were barred from the building after hours. You never tried to use it during normal business hours.
Right. It was during, yes, I only had. Right, because remember the wedding was on a Saturday, I believe. And so I had to go to training on a Monday. So therefore I went to the courthouse on Sunday and everything to get my files and turn over files that I had been working on at the house. So that's the day I went.
So you're not saying anything inconsistent with what other witnesses said. It was Mr. Chamberlain saying you lost your right of access to the courthouse. My understanding was it was after hours access. You don't know one way or the other because you never ended up trying it during regular hours. It got fixed before you got
Right.
back to the train.
Right. And even if it was business hours, I could have come through the front door. I just would have had to go through general population, civilian access entry. So I'm sure I wouldn't have been denied just walking in the front doors during business hours.
And Judge, my question wasn't meant to mislead the panel anyway, the way it is. I'm just trying to get to my
No,
point.
I understand. I just want to make sure I wasn't misremembering. This was a month ago. And
I know. And that's why I'm trying to focus you all where we are, because I do recognize that.
Okay.
Okay. So did it come to did you learn who was responsible for restricting your, as far as possibly we would say your after hour access?
Yes,
And who was that?
it was the Chief Judge Emerson.
All right. Now, at any time prior to that sanction being placed on you, did you consider it to be a sanction?
Absolutely. It was-
Okay.
Yes.
Prior to that sanction being put on you, did Judge Emerson ever try to contact you, get your side of the story, try to determine what you had been told by people like Sheriff Pounce?
No, I've never had a conversation with Judge Emerson.
Right. I don't want you to go over this in great detail because I think it was touched on, although it has been a while back. So I'm not sure of all the particulars, but to be on the safe side, could you briefly refresh the panel's recollection on how you understood your relationship to Judge Emerson to be in terms of ability to communicate with him and access him and have a free flow of conversation with him? How
Well,
would you describe that as succinctly as you can?
restricted. It was impossible. I've reached out via email to his assistants to schedule meetings and it was denied. I've tried to call him. I've tried to just schedule meetings with him directly. He's emailed at me. When I say at me, he's responded to emails when I'm talking to someone else. Someone will add him to an email and he'll comment, but he'll be talking to the other person and not directly to me. But he's talking about me. And he was not able to have a conversation with me directly.
You say that you tried to reach out to him, is that correct?
Several times.
All right.
Even in this instance, when I was locked out, I tried to contact him and see what was going on, to no avail.
We have those emails.
I do. I've submitted it to.
Showing one of them right now.
I understand that she's testified about what's in the contents of this one email that's been printed from her Gmail account.
And a Gmail account is not the government account?
It's not.
Okay. Is what's in your hand something you've ever seen before? You
So-
got it either last night or this morning?
So this was given to us at some point yesterday, and no, I have not seen it before. No, it was not turned over from Discovery.
Okay. Why should it come in now?
Well, for one, I believe that they had access to her, to subpoena her emails, if they wished to.
But if they didn't, and you
Okay, well,
had
I'm
it.
trying to answer your question,
Okay.
and then you can tear me apart.
Okay, sorry, I'll be quiet.
Okay. I can see the fangs coming out already.
No fans.
Okay.
Keep it low.
We emailed it. There was no objection to it. It is a 2-line email. It is corroborating her testimony that she has given under oath. I fail to see that the JQC is being able to establish any prejudice by not being given this 1 2-line email that corroborates what you just testified to.
Okay. Ms. Veal, if you had received this in a timely manner, what would you do differently should you choose to cross-examine Judge Peterson now?
So this is certainly something that I would have explored with Judge Emerson prior to putting him on the witness stand. And I probably would have asked him to provide me with the entire string of emails if there was an entire string. Something else I will note, Mr. Chamberlain indicated this was emailed to me. It was not objected to by me. I have never seen this via email, via any kind of disclosure. I have never gotten this email. And to the point, Mr. Chamberlain's point, that I could have subpoenaed Judge Peterson's emails. This is an email that was sent from Judge Peterson's Gmail account, cjpetersonlaw@gmail.com, on apparently November 24th of 2020. I would have had no reason, or I would have never done a subpoena for her personal email account and her emails in 2020.
Or potentially her lawyer email account, which that could be, and that would raise a whole host of issues. So for now, we'll leave that out of evidence, but you should feel free to continue your line of questioning absent that exhibit.
I will save this for a proper later.
Understood.
To extract the fangs from my neck. All right. All right. So let's talk a little bit about your first conflict, if you want to call it, with Judge Emerson concerning once you had taken office, and I want to focus you on your software requisition.
Okay,
Can
that
you-
wasn't the first conflict, but okay,
Okay, all right. That wasn't the first.
okay,
It was one of them.
yes.
So let me focus you on that first, and then we can go back to the others. You were trying to get an update on your software, is that correct?
A new
I'm
software.
gonna object to, I've given him some leeway with leading, but I'm going to object to leading.
Okay. You've been helping focus. You're not going to be able to focus a whole lot going forward
Okay.
because it's now been objected to. But I appreciate the approach you've taken. And now we're at software and Judge Emerson and Judge Peterson.
Let me talk later. Let me let her go.
All right.
All right, now, Judge, what I want you to do is explain to me what events transpired between you and Judge Emerson in the way of you getting your software change that you wanted. You wanted to go from
Icon to
And if
CJ.
you will explain what the chronology was of what happened.
Well, when I came in office, well, actually before I came in office, around October, I started asking for my budget. I started meeting with all the other probates in the Metro District 3 to see what was necessary to run an Article 6 probate. And they gave me information, Cobb County, Fulton County, Henry County, all of these are Article 6. So they gave me the information and what I needed to run as an Article 6, a fully operating court. So I asked for my budget. Obviously, it was objected to by Judge Emerson.
Okay, what do you mean, obviously?
Well, when I say obviously, at the time in November, when they were doing the budgets, I asked for the budget and then Judge Emerson went on, he sent a letter to myself, copied me and all the county commissioners advising. In that letter, it appeared he was expert at probate and all the affairs of probate. And he was telling them what I do and don't need and why I don't need
Let me
things.
stop you right there.
No objection.
Does it?
Your Honor, at this time, I would like to move in exhibit number 33 into evidence as a December 4th, 2020 letter from Judge Emerson.
Do you have an exhibit list? Because 30, I think it's your first one, so I'm surprised that it's
No.
number 30.
You introduce. Well, these were out of order, so the numbers are not in order.
That's okay, and it can be any number you want, but the fact that it's a 30 says to me that you might have an exhibit list. And if it's in a binder we already have, I'm happy to look at that.
Know whether it's there or not.
I don't mean to throw you off. If it's not easy to get one, I can just keep a manual list. But since you said this can be pretty brief, it doesn't sound like there'll be a whole lot of exhibits.
We tried to pull out stuff that's duplicative. I got a list yesterday from the fourth quarter of the ones we already had admitted.
Okay.
Some is sticky. No, they're not consecutively numbered. They're different numbers.
Okay. Don't worry about it, Mr. Chamberlain. We'll circle back. This is number 30.
This is
And there's
number
no
33.
objection.
This is
33.
33, yes.
Okay, this is
Respondents 33,
is admitted.
admitted.
Okay.
Judge, I'm showing you, respondents number 33. Is that the letter you were referencing concerning Judge Emerson's letter?
Yes, that's the letter. It came through an email, but yes, it was a letter. This is the letter.
All right, and I'm not going to go through the contents of the letter, but your impression from that letter, succinctly put, was what?
Well, he was opposing everything that I had researched from all the other probates on what I needed. He was telling them that I didn't need anything that I was asking for.
Let me stop you there. Did he, prior to sending this letter, ever contact you, write you, email you, offer to discuss your budget request before he sent that letter?
No, and I actually I sent an email to his clerk in November, a couple of weeks before this, and I said, hey, I'm the newly elected. I would love to meet with Judge McClain because he's the chief judge, and I bet he would be excellent resource for me to help me transition into this court. And it was declined.
You said McLean.
I'm sorry,
Emerson?
Emerson, I'm sorry, Judge.
It was declined.
The meeting request, I scheduled the meeting through Judge McClain. I'm sorry, Judge Emerson. Sorry, Judge McClain. Judge Emerson. It was declined by.
It was, that's all I need to know. A name, when you say it was declined, who declined it? It's just a name.
Well,
At the meeting, I believe it
was the meeting.
Anyways, you're not being.
let me do it. Okay, so the meeting was declined. I emailed Emerson's assistant. She scheduled the meeting with me and then came back and said, we are canceling the meeting.
You say it was declined. I just want to know
The
who
meeting.
declined.
Yes,
A name.
Judge Emerson's, yes, and not Judge McClain. I'm sorry if I mentioned Judge McClain. That was,
Judge Peterson. When you say that, I haven't seen the letter, so Judge Emerson, I guess, objected to your request. As part of your request, were you requesting for money for the software upgrades?
I was requesting a full budget. It was for everything. So it was line items for everything.
Within that, what new software?
Well, it didn't specify for him, but it specified for minor equipment or equipment improvement, software, things like that. He wouldn't have known necessarily, but it would have said, he would have only known what the line items were.
Let me, I'm sorry.
No,
Let me rephrase it. Were you at this time, when was this letter dated?
December 4th, 2020.
2020. So you had not assumed office yet.
Right.
At this point, are you requesting money for a software update?
No, I was requesting money for full operation. So it encompassed everything.
And when did you request money for software?
What I had budgeted. So when I got into office, how I had budgeted covered it. So, and I came up with an agreement with CJT, so it would be, it would be budget neutral. So it wouldn't really affect my budget to get the software.
Submit the request to the county governing authority or to someone else?
For the budget, before I came in, the reason I did it before I came in office is,
I just need to know.
okay, so for the budget,
Did you submit the request to the government?
for the budget, yes.
Thank
Okay, software, no, it's, yeah.
Did, in your recollection, Judge Emerson ever involve himself in questioning your request for a software change? And if so, could you explain how that occurred?
Yes, I learned first. Okay, first, when I got into office, I had a 90-day plan on things that I needed to immediately change. And one of those, I was looking into software. When I made the decision to go to CJT, which the majority of probates are on CJT, I made that decision as a constitutional officer to go to that software. Well, I utilized my budget to pay for the portion that I needed to pay for. And how our budget works, when we input it in New World, it has to be approved by the county clerk, the purchasing director, the financial director, and then IT. Well, everybody had approved it but IT. I sent an email to IT and the county administrators and the county BOC and said, hey, everybody's approved this but IT, what's going on? I learned that Emerson was holding it up. Judge Emerson was holding the payment of my software up. That was the.
Do you know, did he contact you before you learned that? Did he contact you to tell you what his reason was or were for holding up that conversion?
No, he's not contacted me. I was contacted by other people on his behalf telling me.
Your Honor, I'm gonna object to yours. And any testimony regarding something she learned from somebody else.
Your Honor, I'm offering this testimony so that you know to explain her conduct and her conduct in communicating with Judge Emerson. And the reason I'm doing that is I'm going to be leading to an Exhibit 12 that was offered by the JQC, which was a very strong email and had very.
This is the one that says you ought to retire, your spirit
Exactly,
is broken.
exactly. And so I believe it's important for the panel to understand the circumstances leading up to this letter and what she was exposed to and how his actions and the actions of the IT affected her to explain this conduct.
Okay, I hear you. But I'm not gonna allow in testimony that someone else said Judge Emerson did X. We had Judge Emerson on the stand, and your side had a chance to examine him and may need to call some other witnesses. Plus, I think that you've already set a pretty good backdrop for how it wasn't a healthy relationship between Judge Emerson and Judge Peterson.
Okay.
Not for want of Judge Peterson making some outreach to Judge Emerson. So let's focus on if it's going to be Judge Emerson did X or Y, it's because he did it in her presence, meaning Judge Peterson's presence, or they had a communication about it.
Okay, all right, very good. So can I guess rephrase to get me focused on this? What I'd like you were explaining to the court, what your knowledge was and what your impressions were of Judge Emerson's activity in approving or disapproving your request for conversion.
Right, I got an email.
All right, and your impression from the people that you spoke to, don't tell me what they spoke to, but from the people that you spoke to or learned information from those, what impression did you get about what role Judge Emerson was playing in regards to your request?
The role that was played was that I needed to get approval from him and or the technology committee before I could move forward with purchasing CJT.
Okay, let me stop you there. Was that in comporting with your understanding of what the rights a constitutional officer had
No,
when they had an approved budget? And if not, Explain why.
No, the Georgia Supreme Court has made it very clear that once a budget is given to a constitutional officer, they have the authority to spend it in accordance with what the approved line items are for. We also have more expansive authority, but I didn't have to get approval in essence.
What's the technology committee?
That's a committee that works, that's for under the county. So the county had its own technology committee. I think Judge Emerson was the chair. And then there's commissioners and other people, and they just talk about how to expand the technology of the county. And they make decisions for county, but they don't have authority for constitutional officers.
Does the support system in your computer system, or is it run through government authorities and
The network is run through the county. I think most offices have contracted through ICON, which Judge Emerson set them up on. And I am different.
emails and all those?
Yes,
So they'd be subject to open records.
not, yes, except judicial. All emails except judicial. Judge Emerson issued a standing order that made it where you cannot get emails of judicial figures through open records.
Did Judge Emerson convey to you? And if so, can you explain to the panel what your understanding was, of the information he provided you, about what the basis for the holdup was?
Did Judge Emerson explain to me?
Let me back up. Did you ever contact IT and instruct them about your rights as a constitutional officer?
I did. And honestly, I didn't, even though these parties were trying to put Judge Emerson into it and they were halting to him, I still communicated with the parties who had the authority to move. So I didn't cater to that. What I did was I knew IT had to approve it, so I went over IT's head and I contacted the county administrator and the chairwoman of the county, because please get your directors to just push the button. That's it. And that's what I had to do. I didn't go back and forth with Judge Emerson on this one because he didn't have the authority. So I didn't lean into that.
Did you ever have any knowledge of an issue being raised about proprietary information or anything like that would slow this up?
After the payment was made, then we have to go into the conversion. So basically, so that was payment. This is transferring into that. So there were two different matters. That was the first, yeah.
So what you're saying is that once, did you finally get your application?
I did. They got out of the way, yes.
Did everything go smoothly then?
No, because
What happened next?
then when it's time to get the CJT, and now I need to get the data from ICON to CJT, I requested specifically to get the probate data transferred to CJT. Well, that was being held up by IT.
How was it being?
We explored that pretty thoroughly.
We'll move on.
Okay.
Can I describe what the basis for that holdup was? Because it does go back to Judge
You
Emerson.
can if it's brief, but we
I
got
will.
emails about that, and I'm gonna sue you.
Mm.
Well, it's private, it's not private, it's this format, it's not that format.
Okay.
So we've been there, but if you want to have one. more
Again, I want to put it into context of what's
Okay.
just going through. Judge, when you contacted IT, what was the holdup with getting your data to the people that were doing the conversion? What was the excuse made?
Well, they somehow, I was asking for probate information only, no database, no software. Judge Emerson emailed me and he was talking at me. He was talking to someone else at me, but he was telling them I wanted the whole ICON system.
Was that correct?
That was not. And I responded to Judge Emerson and said, hey, that's not what I asked for. If you read below, this is what I asked for specifically, Judge Emerson. And he didn't comment. He just did a copy and paste of what I said. And I said, exactly. I said, actually, I just have an open door policy, Judge Emerson. If you want to talk about anything, just contact me. I would love to have your assistance. And I never got a response. He just So, I mean, that's just my relationship at the time with him. But ultimately, the only way I was able to move forward with getting that true conversion is to send the notice of intent to sue. At that time, I didn't have an attorney or anyone representing the probate, so I had to represent the probate.
I'm going to deviate very slightly here. You've been charged also with violation of JQC requesting records from you.
Okay,
You're familiar with that charge
I am.
generally?
yes,
And one of the problems that arose was a location of a record. Do you recall that
yeah,
area of testimony generally?
I do.
Was the fact that the record could not be found, did it have anything to do with the particular application that was in place at that time?
Yes, and that's
What was the application in place at that time?
Icon.
Was
and-
that the one you wanted to replace?
Correct. So when JQC came in my office and requested records from Dekevion, they were asking for a record. And at that time, you only had two places to get records, in my office and in our public vault. Now you can do it online with CJT. But when they came in that application, you only could search for a marriage record by the person's name, not a portion of their name. You had to have their name, their true name. So if they were Hispanic and perhaps had two last names, you had to have those two last names. When the JQC came in, they had no information. They just had the information of, I want the record, the marriage record from the wedding Judge Peterson did on Saturday. That's not searchable in the Icon system.
Okay. Now, we've talked about the budget discussions you've had with Judge Emerson. We've talked about trying to get approval for your software, your budgets. We've talked about trying to get approval for conversions and Judge Emerson. We talked about you trying to reach out to him. We talked about your restriction on your wedding. In all of those cases, to wrap this particular area up, did Judge Emerson, before he took these actions, ever try to talk to you about doing any of these things?
He made it clear I wasn't worthy of a conversation.
All right. Now, so we come to the day of the wedding, and I want to circle back around.
Okay.
The courthouse after hours gets restricted.
Yes.
How do you feel about that now?
How do I feel about it?
Right.
I don't feel like I was being treated fairly and like everyone else. I feel like I was being mistreated. I feel like I was disproportionately. I felt like I was in essence convicted, guilty until proven innocent.
Did you ever have any reason for why Judge Emerson felt that way about you?
I can't explain away or make logic to evil. I'm sorry, that's what it was. It felt like.
Make some fairly strong accusations, Judge Emerson.
Okay.
Can you explain why you were so strong and forceful in that letter?
Because it's what I was enduring from him that I knew firsthand, and not just all the stuff we just talked about, but he also had been submitting complaints to the JQC about me. It was just a lot, and it's just like it was a witch hunt. And my thing was, when I asked them, my first line is, "How are you a judge?" Because I know as a judge, we have a duty under the code to make sure people are treated fairly and to listen to all the evidence before we come up with a judgment. And this man judges me without knowing me, without having a conversation. He'll just say, "You're guilty."
Okay, thank you.
That's why.
You said some big, he filed more than one.
Absolutely. He filed about 3 of them to my knowledge. And yeah, that's.
How do you, I don't know how that process works. How do you know that he filed one versus the woman who was here yesterday?
Right.
submitted things?
Well, when he submits, when when it comes in, the JQC will send a notification letter. They sent the notification letter, and particularly one came in where I knew the JQC didn't have jurisdiction. So I asked the JQC who submitted this, and they told me it was Judge Emerson.
So that's how you, it's not that when you get that notification letter, it says, John Doe, thinks
Right.
you're a bum.
Exactly.
It says someone had a concern, here's the issue, and you said, well, who had this?
Right. Yeah. So I specifically knew somebody submitting something from 2018. And I know the JQC didn't have jurisdiction, but I was like, who did this? And I was given that information. I was like, wow. And I submitted a formal written response to the JQC that he's been harassing me, and they have that. I just didn't know how to receive it, because when I came into the county, I treated everybody with respect, regardless of your political party, regardless of gender, anything, but I just wasn't granted that same right.
Do you think this email was respectful, since you treat everyone with respect?
Well, that was the best way at the best time that I had. And when we talk about respect, absolutely not. It's, but again, that's where I was in that place. And I'm still in a similar place, because I've been going through this for 3 years. So, but I watch what I say, and I try to make it more respectful. And honestly, I just don't really respond to a lot of things, because I know he's not, as you see on that email you're looking at right now, he never responded to me. He just sent it to JQC and said, this is Peterson's response.
Do you have any regret for sending this email?
The regret I have is how I worded it. That's the regret, how I said what I said. But the meaning and the message is still how I feel. I want to know, how are you able to not abide by the code of the judicial canons, and I'm required to? I'm supposed to treat everybody with respect and impartial, but you don't get to. So it was a question. That's the question that was really posed with that. And I was saying, out of all of this, convicting me, restricting my access, you did that without the authority of the sheriff. The sheriff is over the courthouse. And you'd made the one-handed decision to do this. It wasn't right. So yes, I would rephrase it. I would say it right. But I'm not against stating the truth. And I think the judicial code allows me to state the truth.
In your email, exhibit 12 that you were shown, that was a reply to an email that you had received from him, correct?
Yes. So the email that I said, how are you even a judge? It came through from Emerson, Judge Emerson. He sent an email to me talking about how I violated all of these policies. And he copied all of these parties on the email, basically saying I'm public enemy number one. And I was so offended, because this is not the first email he's done that, in which he's made it a hostile work environment for me by copying all these other parties and saying I'm this bad person, I'm violating policies and security policies. He's done that before. So I was kind of like, why?
Is that email in evidence?
Exhibit 12?
Which email?
Email she's describing from Judge Emerson. Is that evidence in it?
Yes, it was submitted by JQC as number 12.
No, I've got number 12.
Oh, you have?
But this doesn't have Judge Emerson's email that she is now describing, and that's what I'm asking. The one where he is accusing her and saying that she's doing all these horrible things. Do we have that email in evidence?
I thought that was an email.
That is, so the bottom, the second page was an attachment. So he sent the email and copied all of these parties. Yes.
Okay.
Are we straight on what I was?
And this is not the first time he's done that. The first time he did that was before I came in office and I was asking for my salary. He sent the email to all the other judges in the county and the Board of Commissioners, telling them how we are basically an inferior court and don't deserve it. This was not the first time.
It's an
Mhm.
objection.
Did Emerson or anyone else ever say you shouldn't be getting all this money because you're making all these thousands of dollars doing records and weddings and all that stuff? Did anybody ever say that, make that allegation?
No, because it wasn't a thing. And I don't know if y'all want to open the door to that, but how the money was reported before I came in office, It wasn't reported right. So it looked like there was not money coming in, but it was. I don't know if we want to talk about that today, but yeah, when I came in office, I reported all the money coming in. So that's why it looks like it is, but it's always been that way.
That's not the question. Question is, did you hear any commentary that you don't need a pay raise because you have this other stream of income
No.
that no other judge other than probate judges, certainly not superior court judges or state court judges, get to enjoy? We have
No.
our salary and that's it.
No,
Probate judge has a salary and a whole other stream of income.
no, it never came in because at the time, it was only reported that the probate judge was making like maybe 30,000 in fees and he was getting paid, what, 90? So that wasn't even a question.
Do you recall in your testimony under cross-examination by the JQC, excuse me, do you recall Judge Emerson's testimony in this courtroom today along the lines suggesting that you copied without justification all these other parties on this email that's been marked as exhibit number 12? Do you recall that testimony?
I do. He said,
Is that true?
that's
That
not
without-
true. I'm sorry. That's not true.
Yeah, you all need to develop a different dynamic because you're talking over each other. Your client, let's get a smoother flow. Most importantly, you need to wait, Judge Peterson, until your lawyer's done with this question, because you know where you want to go, and you all have talked about this, and that's fine, but he needs to be done talking. The court reporter's gonna have a lot of trouble.
Absolutely. Thank you.
Okay.
Please do. Let me complete my question. I'm trying to move it along for the panel, so I may be speaking a little bit quickly, so I apologize. But the bottom line is that, again, my question is, was it true what Judge Emerson said on the stand that you, without any justification, copied that statement in that email on parties, on outside parties?
That wasn't true.
And so your response was a reply to his email.
I replied to his email. His original email copied a lot of parties. I think I might have added a couple, but he had added the majority of the parties to the email chain. It wasn't mailed. He didn't mail me that statement. It was an email.
And that's my confusion. I'm looking at the emails. Judge Emerson emailed Judge Peterson and copied Sheriff Pound and Trent Wilson, and that's it. Her response copies a bunch of other folks. Adds a bunch of, so I don't, that's where my confusion was. You're saying that he added all these people. He was sending you a security email talking about courthouse security and including the sheriff and the person in charge of security at the courthouse. Those are the appropriate people to copy on an email about courthouse security. And then it's expanded to a bunch of folks. I don't know who they are.
Probably the Board of Commissioners.
Kelly Robinson
He was vice chair at the time.
of the Board of Commissioners.
Yes,
And Sharon Subadam.
she was the administrator.
Okay,
So she's over.
so the person who expanded it outside of the group, the initial group was you.
Well, no, you're going by what Judge Emerson sent over to, I don't know if that's the full chain. There's a lot of things that have been entered in the evidence that wasn't the full chain, the complete email.
That's what I'm.
I get it. I sent them.
Well, if you've got more, what we've got here, the email with the content that upset you from Judge Emerson went to two other people besides you, the sheriff, and the person in charge of courthouse security. And it was an email about courthouse security.
Right.
Maybe he should have sent it just to you, but he concluded, rightly or wrongly,
Mhm.
what we're here for, to include those in charge of courthouse security. Your response about how could you even be a judge, you should retire, etc., pushes into a whole new realm. County commission, county manager, and so we are trying to process the exchange you and your lawyer have just had through 4 or 5 questions about how dare Judge Emerson expand this. He expanded it, you didn't, and it doesn't add up. I'm not talking about other email chains. We're talking about Director's Exhibit 12, and the expansion came from Judge Peterson. Unless we're missing something, we want to get it right. It doesn't line up. The evidence doesn't line up with the testimony.
I'm just trying to elaborate on what her recollection was of the exchange. There are email streams that we already have had to introduce some that are out there. Email streams get confusing the way you print them off. And so we're trying to put it in context the best way we can.
Got it.
Well, and I have one more question then. So now that I've refreshed my recollection on this exhibit. So I understand your frustration with Judge Emerson. I do get that. And I understand that that relationship obviously was not the best from the get-go. But Judge Emerson is making a valid point. What he's emailing you is not, he's basically talking about courthouse security, and he, as the chief, I think he was the chief at the time.
He was.
As the chief superior court judge, was in charge of court security along with the sheriff and the sheriff's department. And so he's quoting an article from CNN. Someone came into the courthouse with an assault rifle and did all kinds of horrible things. So that's very much on his mind. I'm having a hard time processing how we go from this email where he's talking about courthouse security, however it was intended, to the first line of your response is, how are you even a judge? I'm having a really difficult time processing how that is an appropriate response to a very legitimate concern raised by Judge Emerson.
That wasn't the only email. There were other emails that said
Your
that.
Honor, I am going to object to the ongoing practice that has happened throughout the course of this hearing. I have introduced into evidence the documents that I was provided. I even didn't remove myself from the email chains that I have submitted. And I turned those over in discovery so that they would have an opportunity to review them and look at them. And what Judge Peterson has done and continues to do is selectively produce email strings or reference them during her testimony. And so I have an ongoing objection to this practice. The hearing panel is now confused, and it's intentional. I mean, it's a selective disclosure, and she intentionally selects things that she wants to casually mention here or there, knowing that they have not been provided to the JQC.
So I don't know that it would be appropriate to prevent Judge Peterson from saying there are other emails, but nothing prevents you from pointing out very clearly that the only ones in the record are the ones in the record. And if Judge Peterson believes that there are emails that support her contention, she has the absolute right and ability to get those in front of us. They are not in front of us. And I think what we're hearing Mr. Lopez do right now is say, everything I got in front of me is inconsistent with your testimony, Judge Peterson. And she's saying, no, it's different. Her word against the actual evidence that's been admitted. So maybe Mr. Chamberlain has another email that you already had. If it's one you didn't have, we know how we're going to handle that. But I'm not going to preclude the witness from saying, no, I promise you there are other emails. You're just not going to get to see them. That last part's not spoken. It is heard. Mr. Chamberlain.
Yes. What I want you to explain to the panel is that this email was not just a response.
That's you explaining it. Your client just explained.
Okay,
there was an objection, not to your question, but to what Judge Peterson was saying, not in response to your question, but Mr. Lopez's question. So I'm going to see if Mr. Lopez has anything he wants to follow up on.
Okay.
He was asking.
All right.
And the director has a standing objection to references to emails not in the record. She doesn't need to make it again. Explain how we're going to handle that and how we're processing it. And your client's going to proceed as she sees fit.
So just to go back to my question, I see Judge Emerson's email, and my question is, why is this the response to this email? You're referencing other emails that may have said, may have created a different tone, and maybe this would be an appropriate email in response to those emails, but we don't have those emails. The email I have is Judge Emerson raising a legitimate concern about courthouse security, and your response starting out with, quote, how are you even a judge, quote.
Right.
That's the disconnect I'm having with this string of emails, not any other emails that are not before us, but this string of emails. This is the response to his email, and I'm trying to process. And
that's the only, well, for that email, that's the one that he actually responded. So that's why you have a response there. There were other communications. I've called and I've sent emails. There was never a response. That was the only one where I got something back. And that's why I'm sorry to interrupt. He sent you an email.
This is your response to his email, not his lack of response to an email you sent him.
Right.
So I'm asking about your response to his. email.
That was the only chain in which he acknowledged my presence. He sent me an email. That's the only one I could respond to. There was many others in which I was communicating and trying to say, what's going on, Judge Emerson? Why is my stuff being restricted? It calls out to him, no response. This is the only thing I got from him. That's why I responded directly to that. That was the only acknowledgement of Judge Peterson.
Is it true that you felt like you had been, I'll use my word, bullied or disrespected, whatever,
Absolutely. It was hostile.
and that you had your fill, and were you just venting and maybe inartfully put all this in there?
Did you want to take a break? Okay, why don't we take our morning break? It is 10:45. We will reconvene a little before 11, please. There, I'll let you in.
Have her appointment go. Keep this.
Okay, civic court is back in session.
We took our morning break. Judge Peterson, are you ready to proceed?
Yes.
Okay. Mr. Chamberlain, well, I don't know.
I think you have a question
Middle
pending.
of, this revisit that.
I do not remember. I don't remember what I asked, but I'm sure.
Back to it if it recurs.
right.
These things should pop back in.
Okay. Judge, the letter of Exhibit 12 that we've been speaking to, your response was in describing it to the panel, was that related solely to that
I'm sorry.
issue? The response that you drafted that we've been talking about in Exhibit 12, was
Right.
that response drafted solely to what Judge Emerson had sent to you, or did it include your feelings and responses to a host of events that had occurred previous to?
It was everything. It was just my response to everything. And yeah, and it was not done. I'm not generally disrespectful. That's not my character. So it upsets me. But I was in this space. I even had to do this.
You were one of the, were you one of the first judges in this area, in this county?
I was the first what?
One of the first African-American female judges in this county?
I'm the first African-American female and Democrat. Yes.
Any publications that you're aware of that ever acknowledged that fact?
I was never celebrated or congratulated. On my day of swearing in, I was sworn in by Judge Emerson. I received my first JQC complaint.
On the day you were sworn in?
Yes.
You said, before that, you said you never what? You never
I was
celebrated.
never congratulated or celebrated. There was not one news article, any TV article that says, congratulations, Judge Peterson, we have a new probate. It was always negative media. And that was put out from whoever. But like I said, when I swore in, Judge Emerson swore me in. That's when I got my first JQC complaint. My first JQC complaint on that day.
Did any of this, do you think, or have you heard from anyone, did any of that stem from the amount of outside money you were making over and above your salary?
No, this was before I got in office.
Like, how much money was that?
Before I got in office?
No, once you took office, the outside money, about how much was it? Ballpark figure. Over $100,000?
You're talking about on my first year?
I'm
Yes.
talking about ever since you took office.
Yes.
Up until right this second, how much outside fees over and above your county or state salary have you received? Ballpark.
Yeah, it was about 100 the first year. But
No, that's not the question, please. I'm trying to help you.
okay.
I said, from the moment you took office until this day right here, how much money over your salary have you received?
I don't know. I don't
You
have
have
it.
no idea.
Well, the thing is, the first 2 years, it was combined.
So
But
like-
that didn't have anything to do with, I'm just confused because he was,
I am too.
okay, because he was asking me, no, that's not the reason why I would get a JQC complaint because of the legal fees that I was able to collect.
Okay, I'm not gonna ask. How much money have you received over and above your salary since you took office up till today? I don't need the exact number, I need a ballpark. Don't you claim this every year with either the file with the Supreme Court, your extrajudicial income?
No,
You don't.
it's
So-
filed on my tax.
So do you file with the Georgia Supreme Court, like the law requires, a report of your extrajudicial income every year?
Yes, but the
Okay,
fees
what-
were not I'm
So
gonna,
you don't include all of your extrajudicial income in the report you filed with the Supreme Court?
they were filed as part,
It's yes or no?
no, now it will be. But before, I was told by the county that it's supposed to be a part of my check. So they put it on my paycheck.
I'm still waiting on an answer, I guess, on, how much money have you received over your income, over your salary, legally. I'm not saying it's illegal.
I don't have the answer. I would have to, I didn't know that I was on trial for that. I would have had that prepared, but I didn't keep up
I
with
just
that.
asked a lot of questions. I'd like to.
I didn't
If you
ha-
want to answer, I guess you have the right.
That's not that, no, it's just I didn't prepare for that and I don't want to say the wrong number.
Mhm. So it's almost $500,000, isn't it?
I don't think that, absolutely not.
Is it over 400,000?
I don't
Are
know.
you looking for the answer out?
No, I'm just trying to understand, like, I would have prepared that if I would have known that I was, am I charged with some type?
I get to ask questions.
Okay. Thank you.
And Judge, I have just a few other areas I want to run by, just from clarification. You recall testimony from Ms. Jordan concerning, a charge related to the petition for administration?
Yes,
And do you recall, her testimony concerning a letter she wrote to the commissioner stating her opinion on your salary increase request? Do you recall that testimony?
I recall the testimony. I don't know anything about the letter.
Okay, but you recall her testifying up to here about that?
Yes,
Okay, my question was, did you know anything about her sending a letter to the commissioner stating her objections to a salary? Did
No.
you ever know that before coming to the courtroom today? Did you ever, or yesterday, did you ever know that that letter had been written by her?
no, I don't have any access to the judge, the county commissioner emails or their correspondence.
Did you have any bias or prejudice against Ms. Jordan or her firm as concerns your entering and signing an order on the petition for administration? Did any prejudice, bias, impartiality come into the picture when you considered that petition?
Absolutely not. The requirement of the notary is something that I established, but it's throughout, it's every case.
I understand.
Yeah.
Your Honor, at this time, I don't have any further questions.
All right. Ms. Veal, do you have any questions for Judge Peterson?
I do.
I have one before you start, but the order you signed about, you said in writing that you allow that to your policy.
No, it's not in writing. I haven't, like, I don't have a standing order or anything. But any case that I've had, I've issued an order of notice on it if it's done that way.
How many of those have you been?
It's been a lot because what I've seen, we've seen cases in which
What's the
it's been a
lot?
good
What's
number.
the lot?
I don't have the number on hand. Maybe out of the estate cases, I can give you a percentage, perhaps, maybe 15% have done it. And I would require those 15% to get new acknowledgements.
What's the concern?
Well, in cases that I've seen when I came into the court, we have estate cases and there will be a attorney signing or notarizing acknowledgements for heirs. And basically the heirs are saying, we agree to this petition. We agree we get nothing from the estate, things like that. Cases, when I inherited this office, I've learned that those heirs perhaps didn't acknowledge, but that attorney was the attorney for the petitioner. So they had an interest to help that person's.
As opposed to a notary who's simply, I'm making sure that Christina Peterson is the person who signs. This
Right,
stuff.
exactly. So to make sure we don't, I've had, my first case was a case that was stolen and, and it had to be prosecuted sent to the DA's office. And the person said he wasn't even an heir to the estate. So I just don't want to have to go through that.
Good afternoon, Judge Peterson. So I want to start by asking you some follow-up questions about what you testified to earlier regarding the wedding and the timeline surrounding those events.
Okay.
What time did you arrive, or around what time did you arrive at the courthouse that day?
Your Honor, I don't mean to object, but I have a perspective. They've already established that previous and examination by JQC.
Okay.
I feel like we've covered this substantially, and
I can ask a more pointed
yeah, that would be probably more helpful.
question. I'm sorry.
Sustained.
So
Hold on.
you,
Thank you, Your Honor.
It's all right. He hit his head again. All right. Take two.
do you agree with me that you allow the first civilian into the courthouse at approximately 2:01 p.m. that day?
Your Honor,
No.
this is video, we have video showing the timeline. I don't understand what we're covering. I restricted my examination. In response to the court, I didn't cover the whole ground all over, and now we're recovering, we've already covered this.
Okay, so
Ask
we're
and answer.
gonna do a couple questions, but if we get into a third question about, and this was after you had talked to the sheriff and so and so, we'll manage it.
Thank you.
Our clocks are aligned.
Thank you.
Okay.
Oh,
Why don't you ask the question again, just so the record is nice and it'll be contiguous.
Do you agree that you let the first civilian into the courthouse around 2:01 p.m.?
I don't recall the time.
Is your testimony to the hearing panel today that you spoke to the sheriff and he allegedly told you what you testified to earlier, before you let any civilian into the courthouse?
When you say civilian, what are you talking about? Because my party was my party. That's who I asked permission to let into the courthouse. The other party was with the deputy, and the door was propped open for them.
So I can simplify it because I picked
Yeah.
up on the same thing. Is it your testimony today that you spoke with the sheriff before you decided you were going to let your wedding party into the building?
Yes, my wedding party.
So you spoke to sheriff, then you let your party.
Yes,
That's the sequence of events, whether it's 2:01 or 1:59, I don't care so much, but sheriff conversation first, he said, go ahead, let them in. And then you let them in, only after talking to the sheriff.
my wedding party. Yes,
That was the high sheriff itself, not a cat. That was.
Right.
Sheriff Mack.
right.
Your testimony today is also that you spoke to Captain Wilson before speaking to the sheriff, correct?
At home. Captain Wilson called me on my phone at home.
Okay. Let's look at Director's Exhibit 65, which is a screenshot of some recording application you had on your cell phone that we've already talked about.
Okay.
So you just testified that you spoke to Captain Wilson at your house before you talked to the sheriff, correct?
Correct.
Okay. We see right here 2 calls to Captain Trent Wilson, and the one I'm interested in is the one at 2:08 p.m. that was, it looks like 1 minute and 4 seconds.
Okay.
That is the phone call that you recorded and that was played here in court, correct?
I guess. I'm not sure.
Okay, well, you didn't record, or did you record the 7-second phone call?
I don't recall. I mean, all of these would have been recorded. These would not have been, these would have been recorded calls, but they wouldn't have been the whole call list or call log.
Okay, because this is an application.
Right.
For phone calls.
Right.
Okay. So, this one that's 1 minute and 4 seconds, do you have any reason to disagree that that's the one that was turned over and played here in court?
No, I don't.
You only turned over one recording of a call between you and Captain Wilson, correct?
Well, I only had one.
Well, you said these are all recordings. Where is this?
Well, if it's 7 seconds, generally he wouldn't have answered. See this where the green arrow is coming up, that means a call is coming in. When it's down, it's going out. And it's 7 seconds would indicate that there wasn't a response or an answer.
Okay, so let's talk about this phone call to the sheriff at 2:31 PM. That was 22 seconds. You testified that these were all recorded. Where is this recording?
I don't know. I don't have access to the app anymore, but the calls that they were turned over to my attorney, the ones that I gave to him.
Okay, so you don't have access to any of these?
No, I tried to contact them as well. I'm saying Cube ACR, the app. I tried to see if I can recover anything because I needed more calls for other things, but no. I turned over what I had at the time.
If the video shows that you entered the courthouse with your wedding party at 2:03 PM, do you have any reason to disagree with the time on the video?
I don't have much. Well, I don't know because I wasn't checking my watch or anything, so
Okay.
I don't know.
Okay, but let's assume that the video shows you entering the courthouse at 2:03 PM.
Okay.
That would mean that your recorded phone call with Captain Trent Wilson that occurred at 2:08 PM happened after you had already let.
Don't answer quite yet, sir.
Argumented in the single facts, not in evidence.
So, it makes a few assumptions and the witness is free to say, given those assumptions, that's right. But I don't agree with the assumptions, but I'll allow the question. Why don't you ask it again now that we've taken a little pause?
Sure.
Mhm.
Assuming the video shows you entering the courthouse with those civilians at 2:03 PM. That would mean that if you called Captain Wilson at 2:08 PM and that was the recorded phone call, that conversation with him happened after you had already let these people into the courthouse. Is that correct?
Yes, that's the assumption.
However, you're telling the panel that you spoke to the sheriff before.
Absolutely. I spoke to the sheriff before I called Captain Wilson back.
Mhm. Do you remember on that recording, you made the statement after he told you, what he told you, that you were gonna have to make some phone calls to some people?
Yeah,
You said that on the recording to Captain Wilson?
yes.
Why would there be a need to make additional phone calls to people if you had already received permission from the sheriff to take those people into the courthouse?
Because this county, the people are the media, there's attorneys, because this county I was uncovering that there was a lot of things going on that they were doing and allowing that wasn't. So they have secret policies or allowing certain things to go on. So I was uncovering, yes, I have calls to make. I called Chairman Jones. I called other commissioners. So yeah, it's a lot of things that's been happening in the county has been under wraps. And I was learning about all these things. I didn't even know sheriff's deputies were doing private weddings after hours.
Was that what the secret policy you're talking
Yes, I didn't know about it until I got there.
about?
For the courthouse? Not necessarily policies, but there are things that were secret, like, for instance, being represented, providing representation to somebody who's charged with something. It's been done for years. To no limit do they pay for representation. They don't ask any questions. But when it came to me, there was all this pushback and obstruction, and it's, oh, we don't have a policy now, or we have to. So I'm learning that things have been done, and I got a whole list of all of the representation they've provided to everybody over the years. And for me, it's like it was put on the news like this was a first time thing. We've never done it, but this county has been spending taxpayer money on legal representation for centuries, years. So just stuff like that. It's just not, I'm not being treated equal to my peers.
Wasn't the deputy who also held a wedding ceremony that day, wasn't he disciplined for that same conduct?
From what I learned, but from also what I learned, he was only disciplined because I was there. If I wouldn't have been there, he wouldn't have been disciplined.
Judge Peterson, my
Yes.
question is, was he disciplined?
From my understanding, I don't have firsthand knowledge, but I read the report.
And you were here when he testified?
Absolutely.
Suspended.
Yes, he said 2 days or something like that.
Not believing.
Oh, no, I believe, he's pretty honest. Yeah, he's an honest man. Absolutely.
In fact, the other deputy who was doing weddings at the courthouse on the weekend was also disciplined,
Yes, Captain Vargas, or Deputy
also
Vargas.
suspended without pay, correct?
Well, I don't know what his sanction was, but I know he received a sanction.
You just said you read the report that you.
Right. I did, but I don't recall what his sanction was. I just know he was sanctioned for the same things. I also read that in his writing, he stated he was allowed to do it for years and never been sanctioned. It was always allowed. So basically, his understanding, there wasn't a policy.
Judge Peterson, I understand the constant attempt to compare you to the two deputies who were doing weddings in the courthouse on the weekends and not security screening. But to be clear, you are the only one who was told right before you went in, do not take civilians into the courthouse because they cannot be security screened, correct?
No.
Who else was told by senior sheriff management, don't bring people into the courthouse on weekends because they can't be screened?
I wasn't told that. She said right before I went in. Right before I went in, I talked to the sheriff. When I was at my house still, that's when I talked to Captain Wilson, and he told me no, I couldn't do it. And he didn't say because they couldn't be screened. He said because my deputies are not there. So when I got there and I saw that the deputy was there, then I called the sheriff. And the sheriff had told me it was okay to go in. So the question posed to me was right before you went in. Right before I went in, I spoke to Sheriff Pound.
2:31 call.
This was before. So I talked to Sheriff several times actually several times that weekend, because after this I got locked out. So it was more calls.
Is there a difference at all in your mind of a sworn, armed, certified peace officer taking a civilian into a courthouse as opposed to a judicial officer in your mind?
Is there a difference? Into a courthouse? No, I guess I would say it would be, but I don't know if he was armed or not. He had on a suit. I just know that that's not my realm. That's not what I do. So that's why I called the sheriff, that's what he does. So I could get counsel from him on what's the next steps and what's acceptable.
I'm looking back at my notes. Am I remembering correctly that Sheriff Pounds has a different recollection from you as to whether he said it was okay to go in?
No, if you were listening to the same testimony, he agreed that he said it was safe and secure and I could go in. But then when he was led on the other, with Bill, he changed his story. So it went all over the place. But no, he said I could have said that. That's what he said. And he said, yeah, if the deputy was there, I would have told her it was secure.
Okay. And you did or did not say to him, you're going to have to arrest me because I'm going into the courthouse.
I've never said that, and that was a leading question from Courtney Veal to him, and
You
he's,
say similar.
I did not.
the exact substance, did you say, you don't have to lock me up, keep me from going in or anything like?
I've never said that I didn't have we don't have that relationship. At the time, the sheriff and I had a cordial, respectful relationship. I can call him for anything that I needed, and that's what I did. I would have never had to tell him that. I would have never had any reason to say that.
Why would the sheriff come here and say that?
He didn't. Courtney Veal asked him.
But you know,
Courtney Bill didn't testify.
I,
Why, and honestly, I don't know why a lot of things were said on the stand because a lot of them were not true.
Is everyone else lying and you're the only one telling the truth? Is that what's going on?
Are you asking?
Withdrawn.
For everybody.
Right.
she's withdrawn the question, and the transcript will show what the witnesses answered under oath, whether the question was direct, on direct, or leading on cross. I just was trying to understand Judge Peterson's reconciliation of what she's saying and what other witnesses, to include the constitutional officer of a sheriff, said under oath.
Mhm.
You agree with me that you were the only individual, and I'm talking about you, and I'm talking about the deputies, that was instructed on April 17th not to take civilians into the courthouse before doing so.
I don't know who else had conversations, but I was told by Captain Wilson when I was at home, there was no deputies there. And to see if the people would, either I can reschedule or have it outside. They agreed to have it outside. But when I got there, I contacted his superior, the sheriff, who said I could have it inside. So I went inside. Since thereafter, I've been doing it outside. People love it. There's no issue with doing it outside. So there was really no need for me to want to go inside. It was the couple who felt like they were being treated unfairly that I contacted the sheriff and got his permission. And I didn't need to call.
What precipitated the call, sheriff, were several things, I'm assuming, but one of them was this young girl saying, and these are my words, Judge, I'm feeling oppressed in that I'm not allowed into this building, yet others are.
Yes, yes. And I saw the mother, her face, talking to her daughter saying, why are we being,
So the young girl said it to her mother.
the mother said it to her daughter in Spanish, and her daughter looked at me. I could read your body language. Well, I couldn't understand exactly what she said. I know she was disappointed and hurt and feeling like she's being mistreated and treated disproportionately. And this is her wedding day. It's important.
Sure.
So I just didn't want her to feel that way.
So again, Judge Peterson, I think we're having that disconnect between you telling us that the sheriff gave you permission and then having listened to the sheriff come here and tell us that he did not give you that permission, especially after we also heard from, make sure I get this right, from Captain Wilson, who had also indicated to you that it was not appropriate for you to go in without screening. And it wasn't that there weren't deputies. The deputies had been there earlier in the day because they assumed that the wedding was going forward at 11 a.m. and they waited and they left, and it was later in the day. So there had been deputies available for screening. It's just by the time you arrived and that the party arrived, they were no longer available. So I'm having the disconnect of, I have now a Captain Wilson who's testified that he told you do not enter without security screening. And the sheriff came here and told us that he did not give you that permission, and that what you told him is, I'm going in, you're going to have to arrest me. I'm having a hard time processing why they would come and say that, something that's so contrary, so completely different to what you're testifying.
I have the same issues. The problem is first of all, I was not told I can't take people in because they need to be screened. That's something that's come out in this trial. I was told I couldn't take them in because deputies were not there. I wasn't given a policy and telling why the deputies needed to be there or not.
What's the difference? I'm sorry.
Who doesn't screen you in your courthouse?
Deputies do, but I'm saying,
Courthouse, they don't have non-screening.
right. And we've had we used like, so I don't know their policy. I've never been explained the policy and I have probate matters to deal with. I can't determine their policy, but I know I had to request deputies to be present. They didn't say people can't come into the building unless they were screened. They said because they deputies needed to be present. That's what the sheet says and all of this. So that's what I did, requested the deputies. And so when I talked to the sheriff, he said, did my pastor deputy is there? I don't know pastor deputy. I couldn't have came up with that term of art by myself. He told me that. He said it's secure. And there would have been never a reason to say, you gotta lock me up. Now, maybe when we had a further conversation, when he locked me out of the courthouse, I found out he didn't lock me out. I found out Emerson did. Now, I probably told him in that conversation, well, you're going to have to lock me up because I'm going to come in and do my job when you lock me out, but not to screen people, not to come in and do a wedding. Absolutely not. I would have never said that or had a reason to say that. But to do my job, absolutely. I was going to come into the courthouse. You're not going to keep me out of the courthouse. So that might have been the statement I said then.
Do you have other areas you want to explore, Ms. Veal?
I do, but there's an issue that came out earlier through her attorney that I've got something I would like to tender for the hearing panel's consideration. It was in reference to Mr. Hyde's question to Judge Peterson about whether or not she had shared previously about this little girl, and that was part of why she wanted to let the parties into the courthouse. And Judge Peterson indicated that she had done a written response to that, and which it's not mentioned anywhere in here. So that's exhibit number 75, and I would like to tender that exhibit.
Has she only done one written response?
To those allegations? Yes.
And exhibit 75 is something that ought not to be new, at least to Mr. Tate, if not also Mr. Chamberlain. Is that fair, or is this something they had not seen before?
Just for the record, this was not an Aiken and Tate response. This was before I was
Understood.
before I was in the case.
And you flagged that there were a series of interactions between Judge Peterson and the investigative panel or the directors, not the hearing panel. I just want to make sure during the course of your representation, you ultimately did receive these documents. So this isn't new to the respondents team.
I don't believe so. I think we've had it.
Okay. All right. Any objection, Mr. Chamberlain?
I've not seen it before, Your Honor. I mean,
Okay.
I'm second chair, so I'm.
Okay, well, let Mr.
It may certainly be appropriate to ask the witness about it, because I think that this was a direct response.
Okay, well, I'll admit it, given the description that's been given to it, and then both sides can do with it as they see fit.
This was a notebook that, just for the record, that I received, and I understand I had all the exhibits, and it only goes up to exhibit number 71.
Right, this is coming up.
It's 78, and I personally not seen.
Okay,
It was also attached to their response to one of the motions. And so it's already part of.
I've seen it before. It's in the public record. Yeah, it's admitted, 75.
Leave it number 7.
Oh, is it 78? I thought you said 75.
We have 75.
Okay,
What's the sticker on the?
75.
Okay.
Maybe my 5 looks like an 8.
Oh.
75 it is. Next question.
You testified earlier that you didn't find out until days later that your after hours access had been revoked, correct?
If the wedding was on a Saturday, I believe, then I would have went to the office the next day.
Sunday.
Yes,
Okay. And you found out because you tried to badge in on Sunday and you couldn't get in, correct?
yes, my understanding, yes.
All right. And we've covered the fact that you then left and were in training that following week, starting on that Monday.
Well, I did get into the courthouse, but yes, I was let in. I contacted the county chair and she got the building maintenance to let me in.
Who was the county chair, by the way?
Ramona Jackson Jones.
The one that's suspended and under indictment now?
Yes.
Okay.
And she's innocent until proven guilty.
Okay.
Time of day did she have to let you-
She didn't let me in. She got the building maintenance to let me.
Was
It was, yes. Well, no, this was on a Sunday.
Was that?
We met through the front door.
You're in training from Monday to Thursday, correct?
I'm sure, yes.
You get back to the courthouse on Friday, and that was the day that you met with Mr. Alford.
I think I got to the courthouse before then, but you're asking me the day I met with him? Yes, Friday. And that's when we talked about me and what happened with the couple and the little girl telling me all that she told me about her mother feeling like that and me calling the sheriff. We talked about a lot of things. He asked me about my salary, and then finally he asked me about the record.
Okay, so you did tell an agent of the investigative panel about the little girl.
Yes.
Okay, I thought I'd ask that.
No, I said I did. When he came to my office, I did. And I said I shared with him information. I told him at the time it was him by himself.
You testified earlier, and perhaps I misunderstood, but that you didn't understand the limitations on your access that had been revoked, and you thought even if you went through the front door during business hours, you would have had to go through security. Did I understand that correctly?
No, I don't go through the front door. My parking lot is in the back. It's
I'm
in,
talking about when your access was restricted.
yeah, I knew that my access was restricted. That's all I knew. I only have one door that I was told to go through. And that's where I park. There's only one door to access the courthouse. I couldn't access it. So for me, it was restricted. I don't know to what capacity, but it was restricted.
Well, and that's what I'm trying to figure out, because the impression we were left with, I believe, after you testified earlier, was that you just were walking around, I guess, down at that conference, thinking that you couldn't get into the courthouse at all, potentially, that just your access had been completely revoked.
I would say I could, well, as I just testified before, I'm sure I could have come through the public door, but the judges are supposed to have some type of security, and that's why they've given us a key to get into the back gate to park in our garage and go to that back door. So if you're having me park in the public way to walk through the public where the public is, I'm not being protected. So you can still say, in essence, I don't have the access everyone else has. So yes, that would have been a restricted form of access because all the other judges are protected.
Who was protecting the wedding?
They would have been generally. I mean, so they were supposed to be there, but they wasn't. So because I still had it scheduled, that's why I still went. And so when I went there, I was honestly happy to see that a deputy was there. So at that time, I wasn't going up there without deputies.
You referenced earlier a few times that you were denied a meeting with Judge Emerson and that it was declined. And I know that we have fleshed that out. But because we don't have any documentation supporting that assertion, I want to ask you about who declined the meeting.
I contacted, well, first of all, there were several communications. The first, which communication are you speaking of? Because I've asked to meet with him several times.
All right, let's start with the first one.
Okay, the first one.
Your first request to meet with Judge David Emerson, when was that?
There was an email to his assistant in November of 2020.
And is that the meeting that you were referencing earlier when you used the term denied and declined?
Well, in the email chain, she set up an set up a meeting with him. And then she told me, hey, in a later email, she said he is having a meeting with all the judges. you should come into that one and we're gonna cancel this one, and I was like, okay, cool. And she was like, I think that'll answer your questions. And I'm like, okay. So I went to that meeting. That meeting was about all the judges, it was about COVID and the extensions and things like that. It really didn't address what I needed. So therefore, I've reached out to them thereafter to speak with him.
That was by email.
No, I've called, I've emailed different things. I've emailed Judge Emerson directly. After that, once I got into office and got an official email, I would email Judge Emerson directly.
You said there was a chain of emails between you and Judge Emerson's admin or assistant earlier in reference to that November 2020 request, yet you showed up to this trial and just brought the one, which was you making the initial request.
I didn't do anything.
Where did this come from?
What are you, I'm not,
The email that you all attempted to enter earlier, it was marked as 32 that I objected to. Where did this come from?
I don't know what you're talking about. I ain't seen it.
Okay.
May I approach the witness?
You may. Fair.
I was gonna follow.
Okay.
Where did this email come from?
That would have been an email that I would have sent. That is an actual email,
It came from you, from your personal.
Gmail account.
CJ
Absolutely.
Peterson law and email that,
Absolutely.
in the way in which your attorneys obtained this.
Your Honor, I'm gonna object, I mean, I'm trying to introduce. I brought the matter, and so now the objection to this exhibit is now being basis of a cross-examination when it hasn't even been intended.
Well, we're not into the contents of it. It's the origin of it. I'm gonna let Ms. Veal explore that. The origins and the presence of, lack of presence of, I promise you there are emails, there aren't emails. I think that's a legitimate topic for exploration. So I'm gonna ask Ms. Veal to keep it focused, but you can continue in this direction.
You pulled this email from your personal email account and would have sent it to your attorneys in preparation for this hearing, correct?
Yes, or giving it to him when he came into my office, one or the other.
You just told the hearing panel that there was a whole string of emails between you and Judge Emerson's secretary in reference to this meeting, correct?
Yes, but it might not have been on that chain. So generally, when I send him emails, like I said, I don't necessarily get responses. When I send, if I send him or his staff an email, he doesn't necessarily respond. He might respond something else, like, hey, we have a meeting with the judges to come to. So there was a different chain. That's the email that I initially sent and asked for the original request for meeting.
Right, but you just testified that there was a series or a chain of emails between you and Judge Emerson's admin in relation to this issue that you emailed her about this meeting.
In relation to the meeting, I didn't say it was a chain. I said there were communications, which means it might not have been on the same chain, but there was actually a meeting that was set up that was then canceled.
You say communications, that could mean a lot of things, didn't it?
Yes,
You just mean email.
yes, but they were not necessarily on the same chain. So,
Say email. Communication.
well, because I also contacted, it was Dawn too. I also contacted her. So we had an email, the original email went out, and then I believe she sent me an email and said, well, he's meeting with all the judges. And so that was a different chain. And she asked me to be a part of it. And I said, sure, I'd love to be. And then she sent me the link. I think that was a different chain. And so then afterwards, when I attended the meeting, which was via Zoom, and found out that wasn't helping, or we didn't talk about anything about my transition into the probate court, I didn't get another meeting.
Same chain or different chain, you have not provided the subsequent communications that you continue to reference during your testimony, correct?
I provided a lot of things. I don't know what was provided to you. there's a lot of things I've provided that hasn't been entered or introduced.
So your testimony is I'm talking specifically about this interaction with Dawn related to this topic, this meeting with Judge Emerson, same chain, different chain. Are you testifying today that those emails would have been given to your counsel?
I believe so. I don't know if I gave him emails about the actual Zoom meeting because I didn't think he thought, I don't know if we talked about relevance of that, but he knew that it happened. I was only directed to give emails that were relevant to what we're doing here today, our trial.
You have continuously characterized that you were denied this meeting and that it was declined to you. But in fact, it was just suggested that you come to an already scheduled meeting that Judge Emerson was having with other judges to discuss whatever it was you wanted to discuss, correct?
That was later. That was a later correspondence that I received from his assistant. And as I stated in my email that you have in your hand, the title was probate court transition. And I was like, I'm trying to transition into probate court, and I would like the assistance of Judge Emerson. So when you have me coming into a meeting with other superior court and state court judges, that's not helping me into probate court transition. So that meeting was not helpful. Moreover, nobody talked to me at the meeting. I was just there. Judge Emerson was speaking his piece to all the judges and they signed off.
You said that once you started and got a county email address, you sent Judge Emerson himself emails,
I
correct?
sent communications directly to Judge Emerson and any other judge I needed to talk to, yes.
When you say you sent communications. Emails to Judge Emerson,
Yes.
saying what?
Different things, whatever I needed. If I had a question about something, I would ask. I would send a question and say, hey, Judge Emerson, can you tell me this? Can you tell me that? Anything I had, any type of question or inquiry where I didn't know the answer, which I didn't know any answers because I was new and learning, then I would send it to who I thought I should, which is the chief judge.
Okay. Did he respond to all your emails?
Most times not. I think he might have responded once or twice.
Where are those emails?
What do you mean? They're probably in the cloud. They're still there. Nothing's been erased.
What cloud?
The county network.
Okay. Did you provide them to your counsel in advance of this hearing?
Why would I need to provide those emails?
Did you
Because
provide
talk about
them?
a whole lot.
Yeah.
How is it that you are confused and surprised why the director is asking you about emails that you have talked about endlessly in your testimony, and she's made clear were never provided to her? How is that confusing to you that she's wondering whether you gave them to your lawyers because she doesn't have them? You've talked about them. No one gives them to us. No one puts them on the screen. It's only your word that those emails happen, and that's the contents of the email. Of
Okay.
anyone in this room, who is it who would be able to source those, provide them to counsel so that we could see them?
Well, I
Who
have
would
provided.
that be?
I did.
It would be you.
It was me, and I did provide. So I had
So on the table over there are those emails?
I provided the county, I asked the county to pull IT, to pull all the emails from all the matters associated with this trial. And I got them and I gave them to my counsel.
And in those emails are emails from Judge Emerson with responses.
I asked for all emails between myself and Judge Emerson, every single email.
Have you looked at what you provided to your lawyers to identify those emails? You know for a fact that they've been provided to your lawyers.
Yes, I provided them. They came to me through IT and I submitted them to my counsel.
Did you look at it between IT giving them to you, then going to your legal team? Did you look at it?
I did.
So when you looked at them, didn't you think, well, golly, these aren't all the emails that I corresponded with Judge Emerson about?
No, they gave me all the emails. I asked for all emails.
So is there a reason why they haven't been presented to us?
I'm represented by counsel.
You said you called Judge Emerson, correct?
Yes, I've made calls.
To what phone number? Was it his cell phone? Was it his office?
I've
phone?
never had his phone. I've never had his cell phone number.
Okay.
So it would have been through the county, his assistant,
I'm sorry. That you asked this show.
Judge Emerson's. Yes, I've never had any direct number. No, I've never really got responses to even feel comfortable with asking for a cell phone number. I wasn't gonna ask anybody else. If I would ask him, it would have been him, but I never really got responses to anything to ask.
So no, you didn't ask.
No, not for his cell phone number, absolutely not.
I don't know how large the Douglas County bench is in terms of juvenile court, and that might not be a real great fit for where you were trying to get help with state court, et cetera.
Mm.
When you figured out that Judge Emerson maybe wasn't gonna be the right source for basically, how do I turn the lights on? You're starting fresh and you're like, any kind of help I'll take. Did you think about going to other folks, or was the culture in that courthouse that you really need to go to the chief judge of Superior Court?
So in regards to courthouse matters, or not even courthouse matters, if they were judicial, I would contact Judge McLean, who has also been there a long time, but he wasn't the chief judge. And if it was in regards to probate matters, I would contact other probate judges in the probate council. In regards to the sheriff's office, after this incident, I didn't really have anyone to contact because our relationship had been strained once they got on Fox 5 and lied and said I let all those people in. So we hadn't really been communicating thereafter. So I really didn't have anybody on courthouse security staff or sheriff's office to confer with, but judicial, McLean, if I had any questions, or any assistant, I guess as much help as I could get from the clerk of Superior Court and probate counsel.
And when you reached out to Judge McLean, did you have a different experience than when you were reaching out to Judge Emerson?
Judge McLean, if I sent him an email, he would respond. And if he didn't know the answer, he would delegate it to someone else and copy somebody or tell somebody to handle it.
Could you please help Judge Peterson?
Yes, he did that.
Okay, thank you.
Mm-hmm.
When you would call Judge Emerson's assistant, what phone would you call from?
I don't recall. It wasn't many times because, again, you don't have to show me many times. It probably was once or twice that I've tried to call to reach out to Judge Emerson.
You made calls and you emails. And I know
Emails are more.
probably generational emails. I know young folks.
Yeah.
But did you ever go to the office and just say, I'd like to see the judge, and I'm gonna sit, I mean, you're pretty assertive.
Mm-hmm.
I'm gonna stand here until I see the judge.
Oh, no, I would have been viewed as aggressive and labeled as such. But let me tell you the honest truth, and you're gonna think it's crazy, but I don't even know where his office is. I've never been shown the whole courthouse. So like, I don't even know where his office is. I think, and I believe it's on the 4th floor, but I believe it's in my courthouse, but I believe it was on the 4th floor. But from what my understanding, when Bonnie has been sent up there to take up like books that came from law library, you have to have a badge to get back to his thing. So I wouldn't have been able necessarily to access that. And I'm not wandering in halls that don't belong to me and I have no business. So if I didn't know where I was going or shown where I was going, I just wouldn't have wandered looking for him.
But this is somebody that, and my word is, it appears to be a toxic relationship.
Mm-hmm.
This is somebody that you felt respected, and you've told us several times, you're a constitutional officer.
Yes.
Just seems to me emails and phone calls at some point weren't working.
Mhm.
So obviously it was a concern of yours. Is that why you didn't go to it all?
Well, because honestly, my work with Judge Emerson's assisting me was not necessarily required. There's nothing that he has to do for me to make me be able to function. It just would have been very helpful. So I wasn't gonna fail at probate if he didn't help me. It just made it a smoother transition if he would have. So when he decided or when he indicated he wasn't interested, I had to find other avenues and I just let it go.
You have told us throughout this proceeding, that essentially you're in Article 6 probate court now. So appeals and any matters from your court, which would have previously flowed to Superior Court, actually now go to the Court of Appeals, correct?
That's right.
What did you purportedly need Judge David Emerson's assistance with?
Judge David Emerson has been in that courthouse a long time. He could have told me the ins and out, who's who, how, what assistance, what's in the courthouse. Like I just found out they have a print shop. Somebody can print our, stuff we might need for our court. They have different things and I know they have a law library. They give access to us for like LexisNexis. When I came in, Judge Emerson didn't have a legal research and a legal research subscription. So, hey, does law library provide Westlaw, with Lexis? Those things I thought that's the first person I would have thought to come to was the chief judge.
All right, and so let's just assume again that there was no option there for you to just kind of get the lay of the land from him. You've testified that your relationship with Judge Bo McLean is different than your relationship with Judge Emerson. How long has Judge Bo McLean been on that bench?
Oh, I don't know. They all been there before I got there.
15 plus years, 20 plus years?
Yes.
Right, and he was there at the same time, correct?
Yes.
Right. Did you go to Judge Bo McLean and say, hey, can you show me the lay of the land? Judge Emerson's not responding to my emails.
I did. I reached out to Judge McLean for inquiries and things that I had questions about. Absolutely.
At the time we're referencing, like when you first took the bench, January, February, March, April of 21?
I don't know if it was that soon. At that time, I had a lot of other things going on. So I wasn't primarily focused on these singular issues that we're talking about. I had everything going on. I had to learn a new court. I had to get new employees. I had to establish CJT and negotiate these things. I had to redecorate this whole entire office that had carpet from 30 years ago that was making people sick and things like that. So I was doing all of these things in one. So when I had the moment and I had a question, I posed it to Judge McLean and he was responsive. And for that, I am grateful.
You mentioned earlier that you started meeting with other probate court judges in the area. You specifically mentioned Cobb, Fulton, and Henry in October of 2020, correct?
I'm sorry, what did I say that year?
You said October and you were referencing the time frame that you were making your budget pitch.
Oh, you're talking about the budget. No, so it's not meeting necessarily. So I video conference with some of them. It wasn't in person. I believe we were in COVID at that time. So I made a lot of calls. Yes, and I conferred with, I believe, Macon and Cobb, and it was a few others, some people that are not Article 6, but I just wanted to get a generalization of how the courts function, non-Article 6 and Article 6, and I had help from the probate council as well.
And I commend you for doing that. It's a very good idea, and I'm not being smart. I think that is a proactive, wise thing to do. But what I'm struggling with is you making a big deal about not, having, access to the Superior Court judges or have them, show you things, yet you were proactive enough to reach out to all these other probate court judges and meet with them, whether virtual or in person, to get you a whole lot of information, it sounds like.
I'm sorry, what was the
I
question?
mean, that's what I'm struggling with. I mean,
Just wanna, question, I don't even know whether it's a question or whether it's a statement. And it seems argumentative to me, like a speech, it doesn't seem like a question.
Okay. Let's ask the witness a question, and maybe that will resolve what you're struggling with.
you got information about how to operate an Article 6 probate court from the probate court judge in Macon, Cobb County, Fulton County, and Henry County, correct?
And there's more, yes.
There's more.
Yeah, I've contacted anybody who I had their number, who I had. Bib. So anybody who I had access to, I would contact and got that information. But it's not how to operate and run a probate court. It was what was necessary. So when I was looking at the budget, I was asking them, what do you have? What type of employees do you have? How do you function? So some of them had staff attorneys, some of them had a fiduciary compliance clerk, some of them had chief clerks, some of them had associate judges. What kind of operating budgets do you have? Well, I need a budget for indigent. I need a budget for this and postage and this. So that's what I needed to know to compile. So they didn't teach me how to run a probate. They taught me what was necessary in the budget, what I needed to be requesting, and how they did it. So some of them I asked for their policy manuals so I can look inside to try to get it. We didn't have a manual coming in the court. So I was trying to figure out how to establish a functional operation. So whatever resources they were able to provide, I took.
The old guy didn't leave you with anything.
Judge Hamrick? Judge Hamrick, oh, no, he didn't leave me with, he didn't have any policy manuals or any written policies. He didn't have a office employee handbook. He didn't have any written things. All the knowledge of how to do anything, how to process a file, how to process a weapons carry license, how to process a marriage license went out the door with every employee he had hired when they walked in.
I'm sorry, were you finished?
I said when they left.
Okay.
I didn't fire anybody. I think I let one go, but everybody else was allowed to leave at their own will.
Do you have an office employee handbook?
Yes, I do.
You said you didn't fire anybody?
I said from Hamrick staff, I let one go. I said everybody else was able to leave at their own will. So when I came into office, I know people were scared because they were like, oh, the judge is going to fire everybody that she doesn't know. No, I told them I'm coming in where I'm learning this with you all. If you're good employees, you're welcome to stay. I don't have any, prejudices against you. I don't know you. I would love to learn your work. Yes, once I established what is required to work under me. You have to follow the law. What I learned was there's things that are not necessarily being done procedurally correct. And when I would correct them, they were like, we never had to do this. And they were not interested in the changes.
So you have made connections with multiple probate court judges in the metro area before you even take the bench, correct? To the extent that they're giving you their policy and procedure manuals, right?
They're very helpful, but you can say connections, but yes, I guess if I could call them if I had any questions, they would answer. There's not many that I just have on the phone line. I think I have one go-to, actually. A main go-to.
And after you appeared in front of the investigative panel in February of 2020, I'm sorry, strike that. After you attended the new judge training for probate court judges in December of 2020, you read the Code of Judicial Conduct, correct?
I don't know if I read it. at that time, you mean read it through? I know we had a training on it, but I don't think we just read it in class.
It's okay if you did. Plenty of judges don't read
Yeah.
from start to finish.
I don't think I read it from,
Allows the job, educated judges on.
I know we had a training on a lot of things, probate at the time, and ethics was one. I think it was a 1 hour situation.
Wow.
I think it was like an hour.
Long.
Oh, I think that was a lunchtime situation, I think, right?
Unhappy that you learn more about the health plan than ethics
Oh,
in new judge training,
right.
often the case.
Just to be clear, new judge training is not 1 hour. In fact, 1 hour, it was 5 full days.
Yeah, how long was the ethics? That's what I was specifically referencing.
You don't get to ask the questions, Judge.
Okay. Well, from my understanding, it wasn't necessarily that long. And in training, if they're training us and if they're teaching me something, I'm not gonna be reading the code while they're teaching me. So if there's a presenter and they're talking, I'm gonna listen to the presenter rather than reading the code.
My question was, after you attended the NJO in 2020, did you read the Code of Judicial
At
Conduct?
some point I did. At some point.
You read it before you joined training?
I don't think so, no.
So your first full year on the bench, you never took an opportunity to
No.
read the code?
This was 2020, before I took the bench. I took the bench in 2021.
Did you read the Code of Judicial Conduct before you came to the IP meeting in February of 2021?
I don't believe so, no. I really read it after I met with the IP, and I believe we talked and had some communications via email, and so I really read that after then.
When you met with the investigator, did you feel like after that you could call any of them with some of these questions instead of people that weren't going to return your call?
No,
No member on the investigative panel who felt like you could.
no.
Steer your what?
I do feel compelled to impose. I think there's a rule against that now. Have an ex parte conversation with the member of the investigative panel. And I apologize, not my witness, I apologize, but
Helpful context.
And I did not know that, so I appreciate it.
Awkward, helpful context.
Not a good rule.
But no, the answer is no. It was a Zoom meeting, and honestly, when I did the Zoom meeting, I couldn't see the whole panel. I could see like a portion. So I didn't even know who was shouting out questions at me.
Hope there wasn't a lot of shouting, but
Well,
I
not,
don't know how that works.
yeah.
Do you remember telling the investigative panel when you appeared in February of 2021 that at the time you made all the social media posts during your judicial candidacy, you didn't understand that there was an issue with it, but now, as in February of 2021, I have reviewed the code and you now, February 2021, understood?
I could have said that.
Okay.
It would make sense to read to prepare for that meeting. That would be logical. I think you asked me that before. I guess from the subsequent issues or posts that the JQC has submitted to me, I was unsure what exactly was being targeted in those posts. And that's what confused me about them. Because as the lady stated yesterday, the outfit was provocative. Well, if I don't I haven't posted anything like that, you know, and then I post about a play and then I have on a nice suit or something, and that's an issue. I guess I didn't understand. I'm learning today because when JQC would send me a notice, it didn't indicate what our issue is.
So we've explored this.
Yeah, we
too.
did.
And Judge Peterson has had a chance to express her confusion and lack of certainty about what the investigative panel was concerned about.
You've read all the JQC formal advisory opinions, correct?
All of them, I read a lot of them. I tried to get through them.
Well, did you say in your affidavit that was attached to your response to the motion to suspend on October 12th of 2021 that I have reviewed the entire website of the Georgia Judicial Qualifications Commission, including but not limited to all advisory opinions, the rules, and the judicial code, recent actions, etc.
Yes, and I think that was at the time whenever that was written, but now that I think the website has been changed, so I can't really tell if I've read everything, but at that time, it appeared that I had read all the advisory opinions on that website.
Well, I can tell you there haven't been any new ones since.
Okay.
You read them all. You're
And in fact, if you read them all, you're ahead of a lot of other judges. So it's good that you, in October of 2021, read them all. You also went to every single ICJE training from 2020 until present that is offered to probate court judges. Is that correct?
Yeah, anything I can learn, I want to, I need to. It's a lot to learn.
That included one in April of 2021, one in May of 2021, one in June of 2021, and one in October of 2021, all multiple days long, correct?
You would have to tell me what they were. I'm not sure. I don't have my calendar.
Okay.
Were these online as well?
April of 2021, probate court judges spring conference, hybrid, Great Wolf Lodge.
Yes.
LaGrange. You went to that one in
I
person,
did.
correct?
I did.
May 26th through 28th, probate court judges conference, hybrid, Chateau Alon, Brazelton.
No. Hold on, May? You said Chateau Alon in 2021?
It was a hybrid, so there was a virtual option and an in-person.
Oh, I must have, if I did it, it was virtual because I don't remember going to Chateau Alon. I have never been there.
You would remember that. June 7th through 8th of 2021, probate court clerks and LWEG and traffic training, hybrid or in-person at Classic Center in Athens.
Perhaps maybe virtual.
Well, you said earlier that you had gone to all trainings.
Yes,
that were offered.
I would definitely go to every, now some of the trainings that I don't get to make it is the virtual ones, the online ones, but most of them that are offered in person, I would go.
October 11th and 12th, probate court judges fall COAG in Savannah. Also
Yes.
a hybrid option.
I definitely went to COAG that year.
Okay, 22.
It's called COAG,
Constitutional Officers Association of Georgia.
Constitutional Officers.
2022, April, probate court judges spring conference, April 11th, 12th, 13th, and 14th at Legacy Lodge, Lake Lanier.
Yes,
Okay. Probate court judges traffic conference, May 9th through 11th, 2022, UGA Hotel and Conference Center.
no, I don't do traffic.
You did not attend that conference in May of 22.
You said it was traffic? No.
July 12th and 13th, 2022, probate court clerks, LWEG conference, hybrid, Marriott City Center, Macon.
I would, if I did that, it would have been online. I wouldn't have, or I don't even know if I did that. I did that, but I think I buy it and I play it for my clerks. I'm not sure because I didn't go to Macon, but I probably did order the video
Okay, and you would have watched that video, that training.
or played it for my clerks because that's a clerk training.
Okay.
LWEG is clerk training.
Okay, October 10th through 12th of 22, probate court judges fall COAG, Savannah.
I'm not sure. At some point I stopped going to COAG because I didn't find it useful.
Well, did you go to Savannah in October of 2022? Right around this time last year?
I think, I know I went at some point last year to COAG, but I don't know which conference it was.
You received a mentor too,
Yes,
when you were a new probate judge.
correct.
Who was that?
Edie Haney, Carroll County.
Okay.
Edie,
Okay. So, when was that mentor assigned to you?
I think after Newton NJO sometime. She's a probate judge. She's newer though. She was newer at the time, but she is in Carroll.
Not as new as you, though.
No, not as new as me, but she's Article 6. Yes, and we had to do like for the probate council, we have to do 1 year of kind of mentorship, but it's kind of, where they tell us to do a certain amount of things.
And
Yeah.
her last name?
Haney, Haney.
Thank you.
So for at least the first year of your judgeship, you had a judge mentor who was also an Article 6 probate court judge.
Yes,
Okay, so you could, with your emails and your questions.
I did a lot, and I still called Judge Haney. Like I called her the other day and she didn't have an answer. So like, I mean, you got to call whoever can get an answer from. So, she knew a lot. We don't know a lot. We don't know everything. So whoever knows it, that's who you got to call around and get the answer from. So I utilized her for what she knew. Absolutely. And she was very helpful and kind.
I'm just going to touch on the records issue briefly. You heard Mr. Buchanan testify, correct?
I did.
Okay. And he never testified that the reason that he did not provide the records was because the JQC did not have sufficient or enough information, correct?
I don't know. I don't know what exactly he testified. I know he said he didn't have the data. He didn't have the information to give to you. And he gave you my email. That's what I remember him writing. I remember from his testimony is he wrote on the sticky my email for you all to contact me, which would have been the way to get the assistance you needed.
He actually wrote on the sticky email on letterhead, your request and the purpose of your request to probate court fax at countydouglas.ga.us per judge orders policy.
Yeah, I don't know why he would write that, but he testified that you all told him to write that part.
So is it your testimony that you had no order or policy in place similar to what he's described on these sticky notes?
Correct. So there's no policy in regards to public records. Public records, anybody can get public records. In the event, and those records could be searched through my clerks for a fee or through the public vault for free. However, when you don't have the record and you want something from the judge's calendar, you need to contact the judge. So I don't know if that's a policy. It's like, I think he was doing the best he could to assist you all. That's not necessarily a policy. The policy I do have a policy similar to that, is when people are looking for birth certificates that are agencies. We don't charge like DFACS. Or the DA's office. We're not charging them for records. So they have to put it on letterhead per the state office and then email their request. That's where that policy comes in, and we waive the fee. So maybe he was thinking because you were doing a search outside, then that would be the case. But probate judge fax, you would reach me to assist you.
So your testimony is that there was not a policy in place, whether oral or written, that individuals requesting copies of records or access to records had to make that request on letterhead and explain to you the purpose of their request.
No, not for public records. Public records is, hey, I need the record for the marriage record for Courtney Veal. A public record isn't, I need the marriage record for the wedding Judge Peterson did on Saturday. That's not public access or a public record. So you would have to contact the judge directly. Yes.
Somebody comes in probate
Mhm.
and says, I'm not sure the names, but my great grandmother got married, or my cousin or whatever, March of 1971. I would like to look at everybody's name that got married March 1971. That's not available.
On the icon system that I was fighting to leave, no. You could only search by the name, and the name had to be exact. You couldn't miss a letter. You couldn't put the first initial. You had to put the whole name.
1970.
No, because let me tell you, when you're talking about weddings, you register the weddings on the day that the marriage license gets. So when you come in and get your marriage license, that's the date. The date of the wedding is another date, and the day it's filed into the court is another date. Icon didn't do all of that. CJT does. So with the CJT system, you might be able to search by the date if it was input correctly, but Icon didn't do any of that.
And what kind of record again would you require a letter?
If it was, well, if it's an agency that's asking for a death certificate of like a prosecution, if you're prosecuting somebody and you need a death certificate, I'm not going to charge our DA's office for that. They have to put it on letterhead so we can send it to state office and we waive the fee. So those requests we have to show who requested it, who the record went to, and why.
So when you issue a vital record, you have to send it, the request somewhere else.
No, we keep it within office, but we're audited and monitored by the state agency. We are county registrars, but we are under the state office of vital records. So we move in accordance with their policies and procedures. So that's their policy. And they also charge for researching records. So if you're coming in to research a record and you don't have the name, it's a $25 fee. So we have to charge you even if we find the record or not, per state agency.
You testified earlier that Judge David Emerson filed at least 3 JQC complaints about you, but you only referenced one. So what were the other 2 that he filed against you?
Well, from the data that you all gave us, my attorneys for discovery, he forwarded the one about the email. He forwarded the one about when I was as a practicing attorney. He forwarded another one.
When you say forward, did somebody else write it for him and he sent it?
No, he was communicating directly with Courtney Veal.
He
Emailed.
sent a written complaint to the investigative panel about you.
He emailed Courtney Veal the complaint. Courtney Veal took it up. So all of these things came as emails directly from Emerson to Courtney Veal.
One is the email, Exhibit 12.
Mhm.
One was you practicing laws at HOA.
Yes.
Okay, and then.
And then number 3, it was, hold on. If I had there's a list of all the complaints. I could tell you which one. There's so many.
They all handwritten from Judge Emerson.
Emailed. Judge Emerson mailed in one, or I don't know if he mailed in, but that was.
The actual complaint form that he filled out, was it handwritten or was it typed?
I've only seen him type up one one complaint, but the rest of them were just forwarded as emails. Like, here's what Judge Peterson is doing. And it was taken up and made into a complaint by the JQC. So the other one, if I can have.
You are characterizing Judge Emerson sending information to the JQC as Judge Emerson filing a complaint against you.
That's what was submitted to us and my attorneys in discovery. It would have complaint number, and then it would have where it came from. And there was no complaint there. There was just the information submitted by the JQC to my attorneys.
So complaint 2021-155, which encompasses the email exhibit 12 that you're talking about earlier, that complaint was JQC initiated, correct? Do you understand that?
I don't know, which one is that? I'm sorry.
The one that encompasses the panic button and the wedding on the weekend and the email that you sent that's in
That's
exhibit
one.
12.
That's one, yes. It was JQC initiated after Judge Emerson forwarded to the JQC. Correct.
Judge Emerson forwarded emails to the JQC, which are related, which are one issue contained within several issues that are complaint 2021-155, correct?
Not to my knowledge. To my knowledge, all of these things were sent to the JQC by Judge Emerson to get you all to make it a complaint.
Okay, so what is the other thing that was sent to?
How did the JQC learn about the panic button situation?
Oh, that's it.
How did the JQC learn about the panic button situation?
From an individual employed at the sheriff's department.
Okay, not through Judge Emerson.
No.
Okay. It sounds like the way you're helping us understand it procedurally is that while you did receive some information from Judge Emerson, the complaint that resulted from maybe more than one submission from Judge Emerson is the one I think you call it 125.
155.
155, okay. Whereas Judge Peterson is construing, and I understand that construction as well. There is a complaint, maybe lowercase c, from Judge Emerson saying, look at this email, and another one that says, look what was going on with the security issue, whatever his other areas of concerns were.
That's correct.
You're helping us understand, the hearing panel, that you may have received more than one communication from Judge Emerson. Those resulted in one formal capital C JQC complaint.
That is correct.
Okay.
This is my fault. When I said complaint, I meant what gets it going, not the formal complaint voted on and filed by the judge. Talking about a citizen complaint,
Mhm.
go on the internet, fill it out, send it.
Yeah.
That's what I meant.
That, from my understanding, what I saw from Discovery and from my direct communication with JQC is the ones that were forwarded to them for them to look at, and the one about the HOA situation that was first dismissed before we even got to court, that was initiated specifically and written out by Judge Emerson.
So I think it would be great to finish the examination of Judge Peterson before we go to lunch. It's a nice accomplishment over which lunch can be enjoyed, but I don't want to rush you. So if you know you've got another 45 minutes with Judge Peterson, it looks like Mr. Tate might not make it that long. So I'm trying to strike the right balance here.
Judge, if we could go ahead and break, and I'll try to narrow down the remainder of my questioning of Judge Peterson, but I do have some additional documents that that I need to print in response to something she said earlier and show her.
Okay. And of course, Mr. Chamberlain, you'll have an opportunity to follow up when the director's done, if there's any redirect. Ms. Veal, I'd ask that you share with Mr. Chamberlain, maybe even before you print it out, the kinds of documents you're thinking about, so we minimize the surprise and confusion. Mr. Tate, how many witnesses do you have to call? You had mentioned two, maybe one. You held up two fingers. So we've got two more witnesses after that. You don't control cross-examination. How long do you expect the direct examination of those two witnesses to last?
Very brief, 30 to 40 minutes at most. With
Each or total? Okay. Either way, we ought to be able to get the remainder of your presentation in before we need to break for the day, so you can get back to where you need to get back to. Okay.
I believe it's taken longer than I thought it would, but I'm sticking by my original plan here.
Okay. Got it. Ms. Veal, anything else before we take a lunch break?
No, Your Honor.
Mr. Chamberlain.
Yes, and at this time, I want to take less than 30 seconds with Proctor number 32, which is examined and which was not allowed to be admitted.
So I'm gonna ask for you to hold that until we're done with all of Judge Peterson's testimony, because that list may grow. And so you'll certainly have an opportunity to do that, but let's wait until we're done with the remainder of her examination. Okay, all right, thank you, everyone. Oh, I'm sorry, great. Our bailiff has wisely said, hey, when are people supposed to be back? It will be 1:45 that we will strive to resume. 1:45.
do in Douglas County?
No, what would you?
Oh, so you're part of it.
Yeah.
But, yeah, I mean, I don't think it's gonna take as much time. Get the transcript for this one, because they've already done the other days, I just wanna make sure we keep. Yeah. Good.
Okay, good. I was getting worried there. I saw him leaving. I was like, oh no.
Good. Okay. Welcome back, everyone. We're starting a little late. That's on the panel, not on the litigants. When we paused before, we had Judge Peterson on the stand, and Ms. Veal had some other areas she was going to explore, although she committed to us that over the lunch break, she was going to refine that a bit. And there was also reference to maybe having some exhibits that you wanted to print out to share with Judge Peterson. And our request to you was that you advance copy them to Mr. Chamberlain so he knows what those areas are. Are you ready to resume your cross-examination?
I am ready to resume. I don't have any further questions of Judge Peterson.
Okay. Did you have any follow-up, Mr. Chamberlain?
No follow-up.
Then Judge Peterson doesn't have to come back to the stand. Thank you. Appreciate it.
It's surprising.
Well.
You guys must have had a good. Nope.
No, I think we covered the thing.
Quit while you're ahead.
Yes.
Let's see, Mr. Tate, who your next witness is.
Call Sandra Hall to the witness stand.
Oh, yes, this poor exhibit. Yeah, so.
Can
Ms.
we go
Hall
ahead
can
and
be-
It'll take me 2 seconds.
No, let's do it. So this is Defense Exhibit 32.
And I just seen that there was another 32, somehow the numbering got messed up, so let's just make it 82. So I know that it hasn't been,
Okay.
and
82.
it is being offered for the purposes of showing Ms. Peterson's attempt to cooperate and with Judge Emerson and set meetings for which she was never given.
Okay, and this is the email that purports to be from Judge Peterson's CJP Esquire. I'm getting it off, but it's not her government work email. It's either personal or her private work email account. Sure.
And it's dated November 4th, 2020 to Judge Emerson's, I guess, clerk or assistant, Dawn.
Okay.
And so that's being proffered. I don't, since it's a document, I guess I'll just hand it to the. What did I say that number was?
82.
82.
Did you?
Part of our.
Mr. Darden? I saw I had a message a voicemail message from him at lunch, but I didn't get a chance to listen to it. Because I was trying to expedite things a little bit. So.
I never mind.
Alacrity. Yeah,
What's your favorite word?
it's one of them.
It's tough.
All right,
Want me to?
No, we're gonna have the
Okay,
bailiff swear in
fine.
the witness. If you don't mind standing up for 1 second while you get sworn in, and we'll get going. Ma'am, if you would state and spell your name for the record, make sure you're near that microphone so we can hear you. Thank you.
My name is Sandra Hall, SANDRAHALL.
Ready for me?
Yes, sir.
Ms. Hall, where do you live?
In Georgia.
And do you live in Douglas County or,
I do not.
was there a time that you worked at the Douglas County Probate Court office?
Yes.
And what job did you have there?
It started as a permit clerk and I was promoted to the office manager and judicial assistant to Judge Peterson.
Okay. And how long did you work there all told?
1 year.
Okay. And would you only work under Judge Peterson?
No, I left the probate court to take a position in the Human Resources Department.
Okay. So you still work for Douglas County?
I do not.
Okay. Where do you work now?
Is that a requirement to answer?
You can answer the question.
I work for an airline.
Okay, that's fine. Did you weren't fired, you left of your own
I
volition
did. I
when you did there. Did you enjoy working in the probate clerk's office?
I did actually. I did.
And what was it like working with Judge Peterson in the said the clerk's office? I think I meant the probate office, but the clerk and the judge are all together there.
I enjoyed my time there. We were a good team. We worked well together. I enjoyed my time there very much.
Okay. I want to specifically ask you if you, tell us a little bit why you were Judge Peterson's judicial assistant. What were your duties and job? What were your job duties?
I oversaw the staff, the front line staff, the permit clerks. I was over the weapons carry license division. I assisted with her calendar, courtroom setup, anything to do with basically just being her right hand.
Okay. And did you, are you aware of an incident surrounding a wedding that took place in the courthouse?
I am.
Okay. And I'm just gonna kind of cut to the chase here. Tell us what you remember about that wedding and how that came to happen.
Well, I just remember that we had a weekend wedding scheduled. Once I arrived there, I came to find out that there was some kind of issue with the time that the wedding was supposed to be for.
I'm sorry to interrupt, but when you say once you arrived there, you were there that Saturday?
I was there.
The Saturday of the wedding?
I was there.
What were you doing there?
I was there to assist Judge Peterson with the wedding.
All right.
I think Judge Peterson's previously testified that she was there. I don't think that.
That's fine.
And
I've been many days ago.
I'm not saying, hey, I remember something you don't. I think that's been sort of out in the domain here.
Great. I asked more, I obviously didn't remember that, so that we were establishing that if Ms. Hall's talking about it because she was there as opposed to someone else told her about it.
And I would have asked more specific questions if I'd realized that.
Okay.
So go ahead and tell, you're there being the courthouse.
Mm-hmm. Yes.
And it'll help if you say yes or no.
Yes,
because
I caught
they've got to
that.
take the transcript down. So take us from there. Tell us what happened.
I just remember that there was an issue with, again, the time of the wedding and that there was an issue now with the deputies not being there for the wedding. So.
Okay. And you weren't with Judge Peterson before you got to the courthouse, correct?
I was not, no.
So you met Judge Peterson there?
Right.
And did you also meet the bride and groom and their party there?
I did, yes.
And who all was there with the bride and groom?
There are 2 children.
Okay. And roughly what ages were they?
I would say the older one was a girl and she was probably between 11 and 12.
Okay.
And a young boy, maybe 6, 7 maybe,
Okay. And do you remember what language this couple spoke?
Spanish.
Okay. And so after you got to the courthouse, you said there was an issue. Just in your own words, tell us what happened.
Well, I was made aware that the judge had made contact with I believe Captain Wilson at that point.
Your Honor, I'm going to object to her going into anything she was made aware of by being told that information from somebody else.
Okay, Mr. Tate?
I'm not going to ask her what, well, I think it goes to explain conduct, Captain Wilson. What she knew about it, what they did while they were there. She was also present, it's my understanding, when Judge Peterson talked to the sheriff and talked to the others and could hear at least one side of that conversation, which I think is.
Okay, if you want to ask her about what you heard, what she heard, Judge Peterson say, that's fine. But some of this background about being made aware of, I'm not sure the source and sounds like it would be hearsay.
Okay, let me ask you, when you got there, what was the plan about where the wedding was going to be?
When I got there,
The revised plan, let me say that. We realized there was an issue with getting in the courthouse. So what was the initial revised plan when you got there?
when I got there, we were going to have the wedding inside.
Okay. Did you overhear any conversations with Judge Peterson and either Captain Wilson or Sheriff Pounds?
I heard her on the phone with someone, yes.
Okay. And do you know who was on the other end of that line?
I know, I can't recall exactly who it was.
Okay. And after that, were you able to tell what her side of the conversation was? Did you hear her side of the conversation?
I did.
And what did she say?
Basically that the pastor deputy was conducting the wedding and the family wanted to be able to have their wedding inside just as another wedding was going on inside. And so, but by then, I guess I can't say that, but I guess, by then we're already inside and waiting for that wedding to finish so
Okay.
that we could start our wedding.
Okay. All right. And did you ever hear Judge Peterson say that she was going to have to be locked up or anything like that?
No,
Was it an impolite conversation?
no,
Did Judge Peterson ever appear defiant to anything that anyone had told her?
no.
Did Judge Peterson, use this phrase, pastor deputy, or you're using that phrase because you know the pastor deputy?
I know the pastor deputy.
Okay.
Yeah.
So do you know if also Judge Peterson said that, or you don't recall if she used that phrase?
I don't recall if she did. I just know him.
Okay. How did you get in the building? Can employees get in on the weekends?
But the door was open,
So you didn't go through, we've heard about the back door, that you need a swipe card to get in. That's not a door that you use?
it is not. The front door of the courthouse is how I entered, but that door was already unlocked.
Okay.
So I didn't have to use my badge that day. There is a badge thing there for you to badge in.
Okay.
Was the door unlocked or was it unlocked?
It was unlocked and open. So when it's unlocked, you can tell it's somewhat ajar.
Okay.
Yeah.
So you were just able to walk right in?
Yes, sir.
So
Did you have to go through the little metal detector or there was no one there?
There was no one there.
I want to just sort of windshield wiper back over this, for a minute. So the door was both open and unlocked and open. I guess it couldn't be open if it wasn't unlocked, but it was both open and unlocked, correct?
Correct.
And there were no security post manned.
No, sir.
Could you see anybody inside from the other wedding party? From the outside?
Not from the outside.
Okay, so when you arrived there, the doors were open and literally anybody that walked up could have opened the door and
Sure.
walked into the courthouse.
Sure. Yes,
Is that correct?
that is correct.
And were you a party or do you recall being present when any of the conversations between the celebrants my understanding is that one of the children sort of acted as a translator. Is that correct?
The older.
Any discussions about that? Do you remember any discussions between them?
Other than just where to be, where to stand, that kind
Any
of.
discussions that you recall about going into the courthouse?
I'm sorry, say again.
About going into the courthouse where the wedding was going to be held?
No, I wasn't present for that.
Okay. And so when you went into the courthouse, did you go any place other? Where did you go to do the wedding?
On the third floor. I think I always get it confused because the first floor is kind of like the second floor. So I think the third floor, just above the entry level of the courthouse.
Okay. And you did the wedding without incident, or did anything happen then?
No, it was beautiful.
Did anybody lock the door behind you when you came in?
No.
And did you see was there one or more other weddings going on there?
There appeared to be one other wedding going on.
And how many people had come in then?
By the time,
With that party, I should say.
well, by the time I got to the second or the third floor, there was quite a number of people already there. But there were people that came in behind or around the time that I did. That was quite a large number of people as well. But by the time I got to the third floor, there was already a wedding. The wedding was already in progress, and there was already a group of people there.
So I want to make sure that I understand this. Are you telling me that the main wedding party, the other wedding party, was already in the courthouse when you got there?
Yes, it was.
Doors were open or unlocked and nobody downstairs.
That's correct.
You all went in, and then are you telling me then that other people from the other wedding party came in after you all?
Yes, because when I walked from the parking lot, there was a limo in the roundabout, and it were a lot of people standing outside that were formally dressed for a wedding. So when I got inside and made my way upstairs, there was, again, already a party of the wedding was already in place, and there were other people that came in and joined in to that wedding party.
And were any of these other people that came in with the other wedding party after you went in, were they escorted in any way
No,
by the pastor deputy or anyone else?
no, because he was already up there when I got there performing the wedding.
Okay. And being there that day, did you think that you were violating any policy by having the wedding in the courthouse there?
No, sir. No,
And why is that?
because we had access to the courthouse.
And you work Saturdays?
Yes, sir. Yes, I had.
But they're ordinarily non-wedding days, just regular probate Saturday. Be deputies in the lobby there, up front and metal detectors and whatnot.
Well, I think I've only been there once for a probate Saturday. But all the other times that I was referring to would just be me entering the courthouse on my own to work
Sure.
outside of regular business hours.
Which is completely appropriate, right?
Right.
I was just wondering if y'all are open to the public on Saturdays, not the weddings, but probate
Mhm.
deputies in the at the courthouse providing security.
Yes. Mhm.
I'm trying not to cut you all off. So, and because you've got to decide the case, I'd rather you ask questions that you're curious about than me. So maybe I should ask another question. Did you ever work on Saturdays, but non-wedding for you, where there were other weddings going on in the courthouse?
No, I've never seen.
And had you ever been instructed not to take anybody into the courthouse? Was there some policy or anything about that?
No.
So if I, for example, were over there on a Saturday and you wanted to show me your office, whatever, you would have felt free to do that?
I would have felt comfortable doing that.
Okay.
Yes.
Nice office.
Yes.
What would you say about Judge Peterson as a judge?
As a judge, I think she's very smart. I think she is very by the book. She's very appropriate in court, like I think she's a great judge.
And if I could have just a minute, please,
Was she a good boss?
She was, yes. Yeah, she was.
so were you involved at all in the change of the computer systems there from Icon to
T, yes.
CJT? Is that what it is?
Yes.
Were you involved at all in the, I may use the wrong, technical term here because I'm not a computer person, but the transfer of records from one place to another, or from one system to the other, from
What?
CJT to Icon, when that was being discussed?
Yes, I'm sure I was around for some of that.
Okay, and do you recall what the problems were? What, do you know what was asked for?
I believe that they were looking for all of the data files from the current system.
From the
From what-
probate court system or from the whole court system?
I believe it was from the whole court system, if I recall correctly. I believe so.
Okay. And did you have any, what role did you play in trying to make all of that happen?
I can't say that I really had a role in that because I wasn't in the IT department or anything
Okay.
like that.
Okay. Let me also ask you, were you working at the probate court when someone from the JQC came and asked for records?
Yes.
Okay, tell us about that.
Well, I was approached by one of the permit clerks to Kivion, stating that there was someone there from the JQC wanting a record from a marriage that had taken place.
When, to give you a first name or last,
First name,
you know, his last name.
if I think hard enough.
That gentleman, when he said, hey, there's someone here from the JQC, did you already know what the JQC was? And if so, why would you know what the JQC is?
At that time, I did know because there was some open, the judge had already had some open situations with them. So the name had been already mentioned around.
Okay, so go ahead.
I can't remember the Kivion.
Well, you said the Kivion came and told you there was somebody there from the JQC. I think that's what you said.
Right, looking for a marriage record. And he stated that he was unable to locate it. And basically just didn't know what to do at that point.
Okay, so what did you do?
Well, I asked him to go back out there and get more information. What exactly were you looking for? What name for the wedding party are you looking for? Because I don't think they had it. From what he told me, he didn't have enough information to give them what they were looking for.
Okay, and on the Icon system, could you look up marriages by the date the marriage took place?
On the Icon system, no.
Okay, and did that change with the new system?
Yes,
And was it the Icon system that was in place at that time?
yes, it was.
And so did you ever go out and interact with the JQC person that was there?
I did not interact with them, but I did go out.
Okay, and can you tell us what was said there that day?
What I recall is the Kivion relaying the information about not being able to retrieve the information for additional assistance, that they could contact the judge directly to see if that, she would be able to assist them. And I just remember him being asked multiple times if he was refusing to provide a public record.
Was he refusing to provide a public record?
He was not.
Was there any way to locate the public record based on the information that the JQC person gave you?
No, sir.
Was there ever in your time any policy to deny public records to
Never.
people that came in?
Never.
Do you know what happened in terms of follow-up with that record?
I do believe that the person came back from the JQC and met with Judge Peterson.
Your Honor, I'm going to object her testifying about what she believes unless she was there and knows what happened.
We heard a lot about it. Do you know about it because someone told you, or you were in the room
I was there.
when it happened?
I was there.
Okay.
But by the way, was Miss Veal one of the ones that came originally having the record, asking for the record?
I believe so, yes.
Okay, do you know what that was about sitting here today? What marriage they were looking for?
I believe it was about the wedding at the courthouse.
The one that we just talked about. Did you know that day?
No,
Did they ever tell you that day?
no, because they didn't have a name from what I remember. So no.
Okay, so while you were there in your presence, what did Miss Veal and the other gentleman that was there, what did they ask for?
The marriage, either the marriage certificate or the marriage license. I can't recall which one, for a wedding that occurred on a particular date.
Okay,
How much time had passed, excuse me,
Hmm.
from that Saturday wedding to when these folks were in the office? Was it a week, a month, just 4 years later?
I really don't know. I would want to say lean more towards within at least that month, within a month.
Relatively close in time.
Mhm.
Why is it, this is a filing question. If I were able to come in there and say, hey, I've been looking for my brother for a long time, and I heard he got married, and I know what date he got married on, that may give me a lead how I can track down my brother. He was married on April 5th in this courthouse. Could you find who was married on April 5th? He's been moving on an assumed name. Why couldn't, if it was within a month, you go to a room somewhere and say, well, he gave me a specific date. Here are all the weddings we handled. And it was only one on that date. Why do you need the name?
Because that's how the system worked at the time.
So everything is
So-
digital. There's not also a paper version somewhere,
There are paper files, yes.
but they're filed by name and not by any other.
They're filed by name alphabetically, yes.
And this problem getting documents that I'm saying is a problem, is that why Judge Peterson, or you wanted to switch computers, making more user friendly?
Absolutely. That was why Judge Peterson wanted to make the changes, but that came from the line clerks stating these were issues. Yeah.
so you said you were there when there was some follow-up. Tell us what you know about that.
Well, there's a gentleman that came back to get the assistance from Judge Peterson to retrieve the information that he was looking for. And I remember that we were in the vault or the information room. I think it's called a vault. I've not been there in a minute, so I'm not 100% sure. But basically, it was where there was a public computer set up, and also record books that went back quite a few years. But you could use the public computer to do your own search for records information.
Okay, to make public, and they're public records, the public can access them, correct?
Correct. The room is open all day during business hours.
But is there anything different if you all assist them with it or look for it? Is there a charge or a fee for that?
No, they choose to use that room. And I've assisted people numerous times, just, trying to maneuver the system and showing them how to maneuver the system, or simply just logging it in for the day.
And do you recall whether or not Devion, did I say
The
that?
Kivion.
DeKevion. Did you ever hear DeKevion tell them that they would need, that they should make a request on letterhead and sort of state the purpose?
No, I don't recall
You don't
that.
recall that?
Mm-mm.
Okay. Was there a policy about what happened if other agencies were asking, other governmental agencies were asking for documents there, and whether there was a charge for that?
Right, so there was there was no charge for certain agencies depending on the purpose. And if they had a legal official reason for requesting the records, they could do so on their agency's letterhead.
Okay.
That was only the way of the fee, that was not to get access to the record.
That is correct. They're still just requesting public information.
That's all the questions I have.
Good afternoon, Ms. Hall.
Good afternoon.
I've just got, actually, I'm not going to say that because a couple might turn into
Please don't.
another couple. I've got some questions for you. You were hired by Judge Peterson, correct?
Yes,
Okay, and you were hired into what role?
a permit clerk initially.
Okay.
Hmm.
And in your capacity as a clerk, did you just handle the weapons carry piece of what the probate court did?
No,
Okay. What all did you handle?
birth certificates, marriage certificates, marriage licenses, did intake on case files.
So you wouldn't have been involved in intake or processing of petitions that came in, like petitions related to estates or petitions for your support, anything of that nature?
Well, initially, that would have been my responsibility until I was promoted. So all permit clerks have that responsibility to learn to intake cases or files on everything that came across the counter.
With the birth certificates, weapons carry, marriage applications, those things, there was not a backlog in processing those matters, correct?
When I was hired, you mean? Is that what you're asking?
Well, let's talk about when you started. Was there a backlog in processing those matters?
When I started, there was a backlog on weapons carry that I was aware of.
Did
Yeah.
you start immediately after the old guy left? I don't mean old in age, prior.
Well,
So it might be, but
so can I just explain something with my answer? Only because it just makes sense. So I was hired in February of 2021. And I really didn't know until months later that the judge had just taken the seat that January, right before me. And I didn't know that because I was new to Georgia. So, and I didn't know her, didn't know the system, didn't follow or anything.
Peterson at all.
I did not. I didn't even know what all of the job entailed until I had the interview. So I didn't know when he left is the answer to your question. Yeah.
So when you started, there was a backlog in processing gun permits. What about the other things you were involved in processing?
I believe that there was, working case files that obviously couldn't move until certain things were done. I'm not sure of if there was any type of backlog in that area. I don't believe that there was, but there very well could have been.
And you don't know that because your primary focus initially
Mhm.
was with the gun permits.
Correct.
You all quickly got caught up on the gun permits, correct?
We did.
Okay.
Mhm.
And you all quickly, well, let me ask you about the other vital, requests for vital records. So birth certificates, those kind of things. Were you all caught up on those requests?
Well, those were pretty much handled as, walk-ins. So they were issued. If there was no issue with the state records, they were issued when the person presented for them.
Did you answer the phone in your capacity as a clerk?
I did.
Did you take phone calls from attorneys or litigants who were calling to inquire about the status of petitions or orders that had been pending?
Yes,
How often did that happen?
I took calls all day, every day. Once, I started as a permit clerk. When I moved to the back, of course, that type of phone call, traffic changed. But as long as I was in the front as a permit clerk, everybody was responsible for taking phone calls.
How long were you in the clerk role?
I would say about 2 months.
Okay, so you were promoted quickly then?
Yes.
Okay, and then you moved to the back
Yes.
and your title then?
I was the acting at first, office manager and judicial assistant.
Okay,
Is there a position called chief clerk?
Yes.
Who was that?
Bonnie, I don't know when Bonnie was promoted into it, but Bonnie eventually became the chief clerk.
So did you consider her your immediate supervisor?
Mm,
You report directly
I reported directly to the judge.
to everybody pretty much?
Well, she had an open door policy, so anyone could step to her if they needed to, but for everyday, situations, they would come to me first. Or if it were really related to an estate case or anything like that, they would go to Bonnie.
Did you replace someone who had been office manager, or you were the first office manager?
I replaced someone,
Who was that?
Treese Clay.
Was there a carryover or an overlap rather between that person leaving and you coming on?
Well, she didn't actually leave. She was actually, she became a permit clerk on the line.
Permit.
No, permit clerk.
Just,
Did I say a permit? Is that the right term?
I don't know.
She was on the line. She was a permit clerk on the line. Yeah.
Ms. Clay was hired by Judge Peterson, correct?
As far as I know, yes.
Okay. So you started there in February of 2021. After 2 months, you moved into this position that had previously been held by Ms. Clay.
Correct. Yes,
That's April of 21.
yes.
And you just testified. What did you just say about Ms. Clay and her no longer being in that position?
She became a permit clerk. She worked on the line in the front office.
For how long did she work in that position?
Several months. I don't know exactly.
Was it a promotion for you to go from permit clerk to office manager?
Yes,
So would it have been a reverse for Ms. Clay?
yes.
Why was she moved?
Due to, I don't want to use the wrong word, but basically she was having some issues with keeping up with the office manager and judicial assistant title with the performance. Her work performance was just not up to par.
Well, who was training her?
I guess she was, I can't say. I don't. I know that, if I recall correctly, she was there, I think, before. I don't want to say that. I'm not 100% sure. I can't say.
Okay.
Well, yes, I can. She was being trained initially by the previous chief clerk, Charlene, was teaching her some things about that desk, about being the assistant. Yeah. As far as the monthly report and things like that, Charlene was training her on those things.
Were you present when Judge Peterson fired Ms. Clay and had her escorted out of the building?
Was I present? Yes, I was present. I was there.
Wow, the answer. It
Yeah.
seems like that would be a memorable event.
Well-
Why the pause, other than you want to be accurate? Which I appreciate.
Well, Because there was a couple of times that she was escorted from the building. So I was just a little bit confused about which one you were referring to.
I guess there was the final time.
Right, so she wasn't terminated the first time she was escorted out, so
So she came back to work after she was escorted out of the building.
that is correct.
And was there another time between the first escort out and the firing escort out?
There were 2 times.
Okay.
What period of time? How close together the two?
Months,
actions?
months.
Her firing, at least in part, was directly related to the mishandling of the weekend wedding that you were testifying about earlier on direct, correct?
Oh, I don't know. That would have been directly related to her demotion.
Oh, okay, so she was demoted for messing up the scheduling for that.
And I'm
wedding.
not saying that that was the reason. I'm just saying, I know that that was an issue. But there were numerous issues with her work performance.
Okay. You testified earlier that you were at the courthouse on Saturday, April 17th for that weekend wedding. And I wrote down, you were there to assist Judge Peterson with the wedding, correct?
Correct.
In what way were you assisting her?
I would take pictures, be there to assist in any way I could with the forms. If she had to sign anything, just present the pen, like just be there. Yeah.
Were you compensated for that?
No, sir, that was just on my own. I didn't have to be there. Yeah,
But you didn't get overtime for being there?
No, sir.
anything like that?
no, sir.
And correct me if I've misunderstood, that was the only time you went to assist Judge Peterson with a wedding on the weekend at the courthouse.
Yeah, I believe that was the only time.
Okay, but you said you went in some other weekends just to get your work done,
Mhm.
right? Did you assist Judge Peterson during your employment with her in performing weddings during work hours at the courthouse?
Yes.
How often did you do that?
Well, initially it was several times a week because it was very popular for people to want to be married by the judge. And then because it became so popular, it was very overwhelming, the numbers and managing the schedule with that eventually it came to just like a once a month kind of like group wedding. So
Judge Peterson was such a popular wedding officiant at the courthouse, you guys had to convert to like, cramming everybody into one day.
well, because it was free. So a lot of people took advantage of that.
Did you handle the scheduling of all those weddings?
I did.
The phone call that you referenced on direct that you overheard, and I wrote that you testified, you weren't sure who was on the other side or you couldn't recall, what Judge Peterson said. Did that phone call that you overheard, where were you at when you overheard that phone call?
I was standing on the 3rd floor.
Okay, so you were already inside the courthouse.
Yes.
Yes, sorry.
And the 3rd floor, again, as you described, that was the location where the weddings took place, correct?
Correct.
And in order to get there, you have to walk in the front door, go up, either take the stairs to the right and get up to the 3rd floor, or take the elevator to get up to the 3rd floor.
That's correct.
Okay. I believe that's all I have.
Before you go, Mr. Case, you got anything? It sounds like Mr. Hyde has a question.
You said the judge was a good boss.
Yeah.
If she told you something and it was under oath, would you believe it?
If she told me something and it was under oath,
If she swore to tell the truth, say something, and she told you that, you believe it?
I would.
Hey,
You know how many times Judge Peterson had talked to the sheriff or to Captain Wilson that day? By phone, I'm talking about.
of the wedding on the weekend.
Yes, yes.
Do I know how many times? I don't know how many times. I can't say.
Ms. Hall, we appreciate you coming down.
All right, thank you.
I'd call Ellen.
We're gonna pause for 2 minutes. In fact, I and I aren't even leaving. Should it be a longer break than that, Ms. Veal?
Have 5.
Okay, we'll pause for 5 minutes
That'd be fine. Yes,
for Mr. Lopez and Ms. Veal.
Thank you.
Yep. But the name of your next witness?
Elva Armenta.
Okay, and that is, as far as you know, your final witness. Okay.
ELVA.
Thanks again for lunch. I'll bring them back when we see them back. Yeah, that was very weird.
How you doing today? All right, what's your name? Oh, good.
Oh,
Thank you, really.
you have a particular judge or something, or sorry, you?
Judges, hey.
They come back. That'd be better. This deal gets here, so.
I've got the witness.
I asked the question, so we'll go back.
Oh, man.
Well, I don't know, he wants, you have this field, so it's not.
Oh, right.
Oh,
I understand. I understand. Go back. Well, that's like. All right, how many times? That?
They'll bring you food, but. It brought them the food, I guess. They were like, also.
Okay. We'll probably get up. Probably. Just gotta watch Netflix. Yeah.
Almost had a job.
Yeah.
Yeah.
And something to watch that. Doesn't matter. Yeah.
Oh, God.
Figure out what they. Yeah, I've seen it on that. Okay. Oh, I'm like, where is it? No, you're fine.
Okay, but. I know. Yeah.
Yeah, no, I got it.
It's almost like I'm a reader.
Back in session, should we remain seated?
You said the name of your next witness. Think she may be here in court?
She is. If you want to walk on up, Mr. Armenta, it's Elva Armenta. I'll let her spell that rather than put a potential wrong spelling in the record.
Okay.
Thank you for being here. If you would state and spell your name for the record, once you've done that, take as a question.
Okay, sure. Elva Armenta, and that's E-L-V as in Victor A, last name A-R-M-E-N-T-A.
Ms. Armenta, we met outside just a few minutes ago. I'm Lester Tate. I represent Judge Peterson. Would you tell me where you live and what you do for a living?
Sure. I live off of 949 Aspen Drive, Lithia Springs, Georgia, 30122. And I'm a resolution specialist. I work
What?
resolution specialist, work for Change Healthcare.
Okay. And
For Change Healthcare.
And what is the subdivision that you live in there?
Silver Creek Ranch.
And is there a homeowners association there?
Yes.
And do you know Judge Peterson?
Yes, I do.
And how long have you known Judge Peterson?
For about 6 years
Okay.
or so.
Do you live near one another?
We live near.
Okay. Have you and Judge Peterson been involved in issues with the homeowners association there?
We have in the past, yes.
Okay. And would you just very briefly, you don't have to give me a blow by blow about everything, just very briefly tell me what your involvement has been?
Well, previously when she was on the board as a president, I served as a secretary assistant when she was running the board. And that was just for a short time. And then after she was gone, I stayed for a little bit, but then I left, and it was just issues with the board. I decided to just.
Okay. So are you aware of, did you accompany Judge Peterson to a town hall meeting for the Silver Creek Homeowners Association at some point?
Well, yeah, I saw her there. We were there at the meeting.
Did you
yes.
go together or did you?
No, I
both
went in
have-
my own car.
Okay. And while you were at the meeting, sort of throughout the meeting, were you in close proximity to
I
her?
was right beside her.
Okay. And that was from before the meeting began until after it was over?
Correct, yes.
Did you two leave together or did one of you leave before the other?
We left about the same time.
Okay. I just want to ask you to tell the panel what happened at that homeowners association town hall meeting. Well, first off, let me ask, do you know why it was called?
Well, the monthly meeting or some type of meeting to, go over some of the things that was happening in the subdivision, and the new president, he introduced himself.
Is that Derek Houston?
Houston,
Okay.
correct.
And
Is he still president?
I believe so, yes, correct.
And so just tell the panel about the meeting. And particularly anything that relates to Judge Peterson and her interaction with others there at the meeting.
Right, so I guess during the meeting, Derek was just talking about some things around the neighborhood, why he got involved. He lived there for 20 years and Consuela stepped down. She was the previous president. She was still part of the board because she wasn't there. It was just him and Quentin Wiggles, the secretary, I believe, that was a part of the board. And I can't recollect exactly everything what was said. It's just towards the end when he offered the president, for homeowners to speak up. Then, Christina, she just was speaking up, voicing her opinion, just like any concerned homeowners as to what was going on or what wasn't going on with the board or with the Silver Creek Home Association. And then Miss Tammy Tatum, she just raised her voice and she sounded angry, her tone of voice, because she was just like, oh, let the judge Christina Peterson speak, just, I don't know, just being really, it was uncalled for. And then other homeowners started to speak out. And I'm trying to think, sorry.
Well, at the time that Ms. Tatum spoke up,
Mhm.
Can you tell me whether or not Judge Peterson had the floor, so to speak, that she's the one that
She had the floor,
recognized?
right, because they gave her the opportunity to speak and she just interfered and just was being all loud.
Okay, and did you hear, well, first of all, in just the comments before Tammy Tatum said anything,
Mhm.
did you hear Judge Peterson say anything that was rude or untoward or invoked her
No, not
authority
at
as a
all.
judge or as a lawyer?
No, she didn't, never mention nothing like that. She was just talking, expressing her, her opinions and speaking up as any homeowner association would, just.
Okay. And do you know her to be a member of the homeowners association?
Yes, she's
Okay.
lives there, yeah.
And so how long had she been talking or had the floor when Tammy Tatum jumps in?
A couple of minutes, I'm not exactly sure. I mean, but she was already speaking when Tammy interfered. I can't remember exactly. But
Is there some history there as to Tammy Tatum's feelings toward Judge Peterson that you're aware of?
yes, there is, because Tammy used to be the president and when rewind back, she didn't want to hold an election or a special election. Then we had to go through the courts, which Christina was the one that did all of that. And we had her removed from president. And I think ever since then, she's just had it out for her
Okay.
personally.
Did somebody mention that Christina Peterson was a judge?
Yes, I think one of the homeowners that were there, I can't remember who.
Okay. Did Christina Peterson ever mention she was a judge?
No, not that I can recall, no.
Okay. And did you hear what Christina said back to Tammy Tatum, if anything, or said about her?
I can't remember. I mean, she didn't say anything disrespectful from my knowledge or anything offensive to her. I just can't remember exactly.
Okay.
What
And
was
how
said?
far away from Judge Peterson were you at the time she was talking?
Right beside her. We were.
Now, was that the end of the meeting? Did it kind of dissolve into?
So yeah, once they had everyone, speak up, and then once it was finished, we were still there with the president and his wife, and I think Quentin was there as well, right when the meeting was done and over with.
Okay. And were you present when Judge Peterson talked to Quentin? I mean, I'm sorry, to
There.
Derek.
Yes, because we were leaving out together.
Okay. And anything inappropriate or rude said there?
Not that I know of, no.
Was it a pleasant or unpleasant conversation?
It was a pleasant conversation,
Okay.
very cordial.
Did Judge Peterson ever invoke her authority as a judge or a lawyer while she was talking to him?
No, never,
Okay. Did she give any legal advice?
no.
What they talk about?
Just basically, she was just explaining to, or Derek, from what I can gather, what I can recollect from my memory, as far as, we should hold a special election so the community can choose who should be on the board, to give that opportunity for everybody to, vote and vote for a board, a proper board.
Okay.
There's something improper about the board as it existed back then when this conversation happened.
I mean, he was just saying that he would have to check with the people that was running the home association, and I mean, I guess he was new. I don't know. It's just, to me, I felt like, I guess he wasn't. I mean, he would tell us we would have to meet quorum, and which we would never meet supposedly. I don't know, but it's just.
Do you have any concerns at the time of this town hall meeting that your HOA board was somehow improperly formed? It sounds like Judge Peterson did, but I'm curious what you.
It was questionable because, I mean, he said that you know, he was now president. We don't know how he got to be president, and it was just him and Quentin, and then Consuela. I mean, she wasn't present, but then I heard she moved or was selling her home, but it was just two of them. So we need to have three on the board. So it was just kind of questionable. I was concerned.
That's all the questions I have for this witness.
Good afternoon.
Good afternoon.
Ma'am, you indicated that you've been a member of the HOA for about 6 years. Is that correct?
Yeah, I've been living there for about 7 years, more or less.
Okay. And did you meet Judge Peterson in your neighborhood? Is that how the
Yes.
two of you met?
Yes, ma'am.
Okay. Is Judge Peterson a friend of yours?
Yeah,
Yes.
yes.
Okay. Have you all been friends that entire 6 or 7 years?
Yes.
Okay. You socialize outside of HOA events?
Not really.
Only at HOA events?
I mean, I've seen her at HOA events, and then I've taken care of her dog.
You mentioned you were the secretary to Judge Peterson when she was the president of the
Assistant
HOA.
secretary.
Okay, when was she president?
Good question. That was, I want to say 2018, 2017, 2018.
Okay.
I'm not exactly sure.
Judge Peterson became the president of the HOA as a result of prior litigation where she obtained a $70,000 settlement, correct?
Oh, correct.
It was the result of that litigation that she wound up in the president role, right?
Where she got voted on, where we chose her. Yes.
Okay. And then you came on at the same time as assistant secretary.
Not right away, but yeah, a little after. Yes, I came on.
Okay. You mentioned earlier that it was a short time that you all served on the board. Is that
Yes.
correct?
Mhm.
Okay. Why was your service on the board just for a short time?
Well, after she left, Judge Peterson, but she left because she was no longer president. Then Consuela became president since she was vice president, and then we had Quentin, and then we had Jerome. He was on the board as well because it was 5 of us. So then, when I was on there, Consuela just wanted to micromanage me. She wanted my password to my email for the HOA. And then she was just talk to me all rude, like a little child, and would tell me, oh, don't go back to Christina, and telling her what we discussed, little things like that, that I just felt uncomfortable. And since I was offering my time, I said, you know what, this is too much. I can't, this is stressful. I'd just rather step down and not be part of the board.
Okay. Why did Judge Peterson cease being the president of the HOA?
Again, Consuela, Jerome, and Quentin, they were just doing things behind her and not consulting her, wanted to choose a landscaper without looking at all the bids, just doing what they wanted to do without even, letting her do her duty as the president. And
Okay, so Judge Peterson's out as president, Consuela comes on as president, and then ensues additional litigation, which was filed by Judge Peterson against the HOA, correct?
correct.
2 additional lawsuits, one in 2018 and then one in 2021, I'm sorry.
I believe, I'm not sure. I just know when I was on the board, I mean, she wanted the membership list, and Consuela refused to give it to her. And I tried to tell him, hey, let's give it to her because this is all over again from the first lawsuit. I wanted to prevent, any lawsuits, and they just didn't listen to me. So I just said, you know what, this is too much. Let me just step down from this. I can't remember after that since I wasn't part of the board anymore.
Okay. You indicated that Judge Peterson's behavior and the things that she was voicing during the course of the HOA town hall meeting, March 31st of 2022, she was like any concerned homeowner. I wrote that down. Those were your words.
Yes, ma'am.
Was any other homeowner asking Mr. Houston or debating with him about the legitimacy of the current board at the town hall?
Not that I can remember.
Was any other homeowner at the town hall urging Mr. Houston to call a special election?
Not that I can recall.
And surely no other homeowner at the town hall was telling the board and Mr. Houston that if you call a special election, I'll dismiss pending lawsuits, correct?
Yeah, I don't recall.
That was just Judge Peterson.
I don't recall.
Well, you said that you were standing right next to her, correct?
Right, but it's been a while back. I can't remember word for word.
You were standing right next to her during the Q&A portion of the meeting when she urged the board to call a special election, and if they did it, she would dismiss her lawsuit, right?
I was beside her. Yes.
Okay. Did you hear her say that?
I believe so, yes.
And having a special election was the subject of pending litigation at that time, correct?
Not sure.
You testified earlier in response to a question by Mr. Tate that Judge Peterson never mentioned that she was a judge during the course of the town hall meeting, correct?
Correct.
But she did mention that she was an attorney when you all stuck around after the meeting was over, right?
No, I don't remember that.
How close were you standing to her when you two stuck around
I was
after the
beside
meeting
her.
was over? You were right beside her? She did not mention a judge, but she did mention people following the law if they came into her courtroom, correct?
I don't remember that.
The portion of her interaction with the board, primarily Mr. Houston, after the meeting was over. You indicated earlier that you recall her making the request that they call a special election, right? Right. Do you recall Mr. Houston saying, I'll take it to our legal counsel?
I mean, he said he would take it to the people who was over running the board or the home association. I can't remember exactly what he said, but.
How many times did Judge Peterson ask him after the meeting was over to hold a special election?
I don't remember.
That's all I have.
Any follow-up? Thank you for coming out.
Thank you. Thank you.
Okay, any other witnesses?
No more witnesses, I just want to check out the exhibits.
Sure. Why don't we do this? Why don't we, take, about a 15-minute break? We'll come back after 3:45. You can look over the exhibits to see if there's anything that we can supplement, confirm, the things we're like we did at the end of the director's presentation. And then, we can talk about how we're gonna use, the rest of our afternoon. We have a little bit of time. And I know when we were back in the jury room, we talked about a few options, but we'll take everyone's pulse and see about what they want to do. But it sounds like you're prepared to rest, subject to any of the exhibits we need to tie up.
All my exhibits are in, or if that tender, all my exhibits are in.
Okay. Ms. Beal, do you intend to put up any rebuttal, assuming Mr. Tate rests when we get back?
Can I update the panel when you're back?
Sure. Is your expectation, if you do have any rebuttal, that we'd fit it in this afternoon?
If I could get that person here, I would.
Okay. All right. You can update us in 15 minutes.
Okay.
Thank you.
Could you please?
Right.
That's right.
Tab of what went in yesterday.
Can you do it again?
If you don't.
No, double check this.
Gave me a list. Yes. First is official.
Let's, you have. Yes.
So we've got. Got 32. You got it?
There is probably something.
So this one, 33 is today, is that right? So, okay. Look at this.
I guess, I don't know. She has a list. I don't know what those numbers mean.
Yeah, 82.
82 was Crawford. That's here. The Crawford was not it. Yeah, I know. One, yeah.
Got
Well, right, I think so. The list that y'all gave us yesterday, like the number one on that list was different than the number one that was reflected in the transcript. So
So this one is this one?
this is our number one, the list that you've been giving us.
I didn't put it in.
Right, see, okay, this is JQC number one for social media.
Right.
Your list says number one is a marriage license, so I don't know what all these numbers correspond to. But the number one that was tendered in the transcript, different. It was Judge Emerson JQC.
Yeah, I put that in. It's number one, 22 number one. But the JQC one is, I put that in. I don't see another number one. Here's your. Oh, okay, it's not. That's what I don't. I don't. Not this file. That's there. Just need to make sure. Was it attached to the?
Okay, found one. Okay, here's one. Let's put a pile for our exhibit. This is one, so check off one. So let's find 19. What is 19? The what? The investigation? Give the investigation over there.
The internal affairs.
Internal affairs report. That's not over here.
Copy of it, but it is not a part of that.
They have it.
I don't know.
Because
Yeah, that might be.
so. Yeah, I think they have USBs with their exhibits. Yeah, they've got USBs. What the- We, I'm sorry, well, that's, we don't have. No.
Well, I think we know what went in, we just don't see it. You think they're up?
Could you? Know what your exhibits are, right?
Yeah.
I'm thinking that maybe they ought to assemble their exhibits in one pile, but we know what's left. Do you understand what I'm saying?
So you got, those are there, but we have to. So I've got a copy of that IA report over here that's not marked, but we need to get a copy of that.
The Excel spreadsheet. No, that's not it. Hour number 18. This is 29.
What's back in session? Please remain seated.
So we need to put other exhibit numbers to match what's there. I know, but that's why don't you go, yeah. Something.
That's good for you.
That's not here.
Oh, we got. No, that's.
Another time.
You have to tell them. Over.
It's a plural.
Fair enough. I decided number 12 and I gave it back.
Just the filing you fellows gave us. That are not originals.
What's missing?
Well,
That were admitted?
we know what,
Well, the same person probably got my.
we have six. We have six.
That you can't.
I know what they are, they're not up here.
Are they reproducible?
Oh, yes.
Okay.
Yes, that's certainly possible.
I think this was state stuff. Hearing channel stuff.
So I think what I would,
Let me make sure I'm not, I have a, was it? No, these are 68 is a copy of this. Six. Yeah.
mine are not sequentially numbered. We didn't, not, but we introduced stuff and whatnot. And I know what they are and I can put it on. the record.
Let's get it on the record and then you can provide substitutes and we'll handle it that way. Ms. Veal, you agree that the 6 he's talking about are things that were tendered and admitted?
So if we found that.
Okay.
Then I've got the original then. The letter she wrote after the, have sent them to the sheriff, which I cross-examined. And then this letter in Clarence Lake, which we have here. And then that one went in today, it's up there. Yeah.
So just those two.
Yeah. Yeah. Yeah.
Okay, yeah.
All right. I think we're good and I can put this on the record.
Sir.
So the exhibits that I'm showing that are admitted, and I think we're in agreement, I just want to make sure it comport. I've gotten this from the court reporter, I want to make sure it comports with the panels, but Peterson's exhibit number 1, which is the JQC complaint filed by Judge Emerson. We have a copy of that up here.
Okay. Labeled as Peterson 1 or respondent 1?
Label is Peterson 1.
Okay.
And then we have an internal affairs report, which came from the sheriff's office that I used when I was cross-examining the sheriff. It's marked as Peterson 19.
Okay.
And then there is a letter that Judge Peterson sent to the sheriff after the wedding incident, which the sheriff testified about. That's marked as number 32. That one, we're going to substitute a copy in because we don't find it up here amongst the documents.
So the internal investigation report you all have found, I didn't see anyone.
No, it's not been marked, but I have a copy and
Okay.
I will.
I remember it being in a binder and you sharing it with folks.
Yes.
Okay.
Yes. Then you'll recall there were exhibits 29 and 30 for us was a letter from Chief Justice Boggs about clearance rate at the probate court from, I don't even remember the acronym for the, but we've got those.
Yeah. The
30 was
workload assessment group.
the certificate. So they, even though they came together, those were 29 and 30.
Okay.
And then 33 went in today, which was Emerson's letter to Ramona Jackson. So I think everything's either there or we're in agreement to substitute with that. But
Okay.
like for the IA report, I need to get another copy of it to do that,
Okay.
substitute it in.
Ms. Veal, you're comfortable with those representations?
Can I, before you do that,
Yeah.
Not yet. Ms. Veal? Did you have any concerns with what you heard Mr. Tate say is the state of the record concerning respondent exhibits?
With the exception of he didn't address 82.
Which was proffered but not admitted. It's just.
Right, 82 needs to be made part of the record, as in would be available should something go to the Supreme Court. We don't need to see it, so I guess it would stick with the court reporter. And then Mr. Chamberlain.
Yeah, what happened is, and I was reminded by Judge Peterson of this fact, that during the course, exhibit number 1 was first admitted in its entirety, but then portion of it was withdrawn later. So there is a large section here that's here, this section was withdrawn.
I think we only put the.
You only put the first couple pages in, so I just wanted to make sure that was clear.
Okay, are you holding respondents one? I thought there was already a respondents one up there. But if that's the original, then I don't think we need to put the whole thing in based on what you've described.
Correct.
Okay,
I agree.
great. All right, so then let's strip down respondents one, otherwise we're good.
Yours. That's what. This was withdrawn. That's withdrawn. So, respondent one, we have now, what we put all back just for posterity's sake was attachments to that, which was a whole nother investigative file or whatever, but this consists of 4 pages, beginning with the letterhead of JQC and a page that had.
Okay, great. Anything else from respondent?
No,
Okay,
with those admitted, we would rest.
all right. Ms. Veal, Judge Peterson's team has rested. Is there anything else you seek to submit in rebuttal?
There's not, Your Honor.
All right, then the evidence is closed. And what, if anything, would you like to do, Ms. Veal, in connection with directed verdict motions and summations?
Your Honor, one more thing, for purposes of the record in the JQC exhibits. So when we prepared the hearing panel's notebooks, we included USBs that had the videos and the audios. What I would propose to do is we will create an additional USB with just video and audio and make that part of the record, if that's acceptable to the panel.
Not a problem. We'll just need to make sure that, is there going to be a USB for each, or it's one USB? And we'll just need to make sure that it's plain that that represents exhibit 14 and exhibit 50 and whatever other exhibits are audio, video exhibits.
So I intend to do one USB if that's acceptable and just have the exhibits labeled by exhibit number. There was one that I ended up introducing that was an audio recording provided to me by them. So it's not on the original USB. So that needs to be added. And then I'm glad to make 2 copies and share it with the respondents.
Okay, that works. Go back to Mike. Okay.
Your Honor, I'm sorry if this is the IA report. Can I just have 1 minute to look at the transcript?
Sure. While she's doing that, let me turn to you, Mr. Tate. What is respondents' pleasure in terms of providing overall summation and or some presentation as to directed verdict?
I believe we would prefer to do the summation.
Okay.
And directed verdict still reserved, of course.
Sure, all reserved, and you'll receive direction from us as to how to continue any advocacy. You can rest on the record and say it simply wasn't sufficient to allow any number of charges to go forward, or we'd like X days to provide a brief on those other matters, knowing that we've covered the First Amendment concerns, not just about the Code of Judicial Conduct, but those counts that in your mind implicate the First Amendment.
Are we talking about, and I'm asking because we had some discussion. But are we talking about having like another argument day or a Zoom argument like for an hour or two? Is that the plan to deal with whatever we don't do today, or?
There's not a plan, meaning that.
I kind of chose without.
Sure, there is not a specific design that we have. What will work most efficiently for everyone is if we keep after 5 o'clock today, the remainder of advocacy written or briefing advocacy. That doesn't mean if one or both sides say, you know what, we really do find an hour, it can be Zoom, we'll get a court reporter. We think it's important to argue X orally. We could probably figure out a way, especially if it's Zoom, to connect the 3 of us with the 5 of you and a court reporter, the 4 of us and the 5 of you, to do that.
Can I confer for just a minute?
Yeah.
I think our preference would be to do the closing today, which I think will take about 20 or 30 minutes for my part. And then to maybe schedule that Zoom conference. I think we would prefer not to make further written submissions. That's not to say that we wouldn't if there's something we need to reply to or whatever else, but I think that would be our preference.
Okay,
May I add something?
you sure can.
Yes. One thing that I did put in my brief, obviously my First Amendment is brief. I did put in the footnote 1 that we're reserving right to assert additional arguments based upon evidence that gets produced here. So to the extent I may have a response, as you indicated from Steele, I would, of course, then we would have something to have basic moral argument on, but it would also mean that there might be something that I would have to respond to, not refiling ground, something that she brings up that I need to address.
Okay.
Her response.
So,
I did want to put that.
got it. If we need a written reply to a response we get, if we get a written response to what you filed about First Amendment, we'll let you know. You should not sua sponte file a reply. You can say, I'd like to, but please await direction from us, the hearing panel, to file a written reply. Now, we wouldn't schedule a Zoom or in person, whatever works for people, argument session for directed verdict until any written response had been received, and we'll set a deadline from the director to what you file. So you would have time to digest that and incorporate into your oral presentation any reply you might have to the director's response to your First Amendment brief.
I actually prefer that suggestion, actually.
Okay.
Okay, and that's good. And then the only other thing that I have, as I mentioned previously, is I have those boilerplate motions for directed verdict on, no conflict in the evidence based on material issues with all reasonable inferences. There
Right.
are arguments made on some counts, so do you want me to stand up and just simply say it's these counts that I am moving to dismiss on those, or do you want me to hold back on that?
Hold back. What I heard Mr. Tate say is that anything more we hear from respondent side today from the lectern will be an overall summation. Panel, you've heard this. Here's why director hasn't met her burden, or if she did, it's not a violation of the rules. And if it is, it doesn't merit any sanction.
See,
I don't mean to steal his thunder, but he's gonna argue what he argues.
see, the reason I bring that up is because if he's gonna be making a closing argument on the same counts I'm moving to motion direct verdict on, it makes, well, my motion for direct verdict on those arguments, which are more factual based, it's ridiculous.
It's not ridiculous, and
Because-
we can engage in the mental gymnastics of considering the motion for directed verdict as something that is argued and perceived from the perspective of the director has rested, and that's it. It's also the case that not a whole lot of new evidence was presented today. That's not a critique of any witness. It was all important, it was all relevant, but it's not that we got a whole new landscape of material such that we'll be struggling. Oh, wait a minute. That was something we learned after the director rested. We shouldn't consider that to see, are there sufficient facts to overcome the motion for directed verdict? So this is sequentially very backwards. I hear you, but not futile. Nothing's been waived. And certainly we're not going to be ruling when we huddle today at the end to say, oh, okay, right, director won the case. That would be premature because we would first need to say, you know what, there's a directed verdict on these 5 counts. Let's just take they can join the counts that were dismissed.
All right, so when I argue the motion for direct verdict on those, you know, those type of counts, I still argue with the same detail that I would even if I hadn't had a closing argument made on.
Correct.
Okay.
All right.
Okay, I got it straight.
Excellent.
Thank you.
Ms. Veal, Mr. Tate is going to present an overall summation in a few minutes, orally. I'm not going to be submitting something written, at least not initially. And you understand how we're going to move forward with directed verdict matters. What is your preference as to what you do on behalf of your side?
What is the time?
Well, it's 4:06, so each side will have about a half hour.
Your Honor, I've got the burden. As I explained, my preference, well, I would also like to not do it backward. I understand what you have decided, but I need longer than 30 minutes. And so if my choice is 30 minutes, I guess, can I brief in addition to that?
You may, and certainly the other side will be given a chance to file a responsive briefing. And I'll tell you what I think makes procedurally the most sense and addresses the concern Mr. Chamberlain brought up is that we stop for today and we figure out a time in the relatively near future for you to respond to the directed verdict brief. And then soon after that, we have an oral argument on directed verdict. And maybe even in that same session, we would get to summation. I think that makes the most procedural sense. But I also understand Mr. Tate wanting to say, hey, while this is fresher, because it is freshest now, Mr. Tate, would like to share a few words with you about what you ought to do. And there's not a reason we couldn't do all these things. We were together for 7-8 days, so there's a lot of waterfront to cover. But while it is fresh and we're here in person, because these subsequent proceedings I'm describing could be on Zoom because of people's schedules and availability, this is an opportunity to say, no, watch me while I tell you why you should do X. So you are free to say, hey, I'm gonna give you a little bit today, but I'm also gonna put something in writing. And I think after the directed verdict argument, you should give me a chance to argue a little bit more. And we'd likely say, you bet.
So what you just described as far as what would make the most sense procedurally, is that option available to me even if he goes today?
Yes.
So if he goes today, I can submit a brief as to the directed verdict, we can show up via Zoom, fine, argue the directed verdict, and I can argue my summation at that time?
After the directed verdict, yes. And Mr. Tate would have a chance to say a little bit more on summation as well. Because he may have had a few days to think through it. I got the transcript from the last 2 days. It would be okay for him to say a bit more as well. We do the usual. You would go first. He might say, hey, I have a few more things to add from the 29th, and then you'd have the right to wrap it up.
Okay, that's what I'd like.
Okay, so you would like to say no more today other than thanks and see you. Happy holidays.
So long as I have the opportunity to say something via Zoom as to both.
Yep. All right, Mr. Tate, when you're ready.
I'm gonna do my best, and you are welcome to cut me off if you would like. First thing I want to do is thank the panel because you've obviously listened very carefully and you've asked questions that are both relevant and show an understanding of what is going on here. I want to be brief. It is 10 after right now, so I'm going to try to limit myself to 20 till. One of my theories of closing argument is I don't need to repeat every single thing that has been said before, but that I need to give you some indication, some shorthand of what I'm talking about. So when you go to discuss the case, you'll know that we think it was an important issue. I also will make some brief reference to some things that are in the transcript that we already have. But obviously I don't have all of the transcript, and that usually, because these cases typically go to the Supreme Court, you end up briefing it and citing stuff there. In 36 years of doing this, I have noted that so many cases that get tried are about, can you see the forest for the trees? One side wants to focus in on the small minutia part of what the case is, and the other side wants to say, hey, look at the big picture of what is going on here. And so my presentation to you today is basically to try to look at it from the forest standpoint, because we've had individual witnesses that have focused in on that. So I want to start with just briefly going over once again how we got where we are here today. And that is that in 2020, Judge Peterson got elected probate judge of Douglas County. And as she began getting her budget together and trying to prepare to take office in January of 2021, Judge Emerson began writing letters about the probate court and whether she was entitled to have the compensation or the staff or whatever else that was out there. Now, there was a lot that was said about Judge Emerson here today and about what other avenues that Judge Peterson had there. And I want to make a clarification about that, because the problem was not that Judge Emerson needed to be her mentor, but that he actively began attacking her and that she actively felt like that she was under attack, not just by Judge Emerson, but by some of these other folks. And I'm going to talk about that in a minute in terms of moving forward. And one of the most prescient questions that was asked here was asked by Commissioner Lopez when he asked, you know, oh, well, Judge Emerson wrote you this email and then you wrote back and it was a really nasty, snarky email that I think Judge Peterson would say I shouldn't have sent. And it was not really in reply to that email, but it was in reply to everything that went on before that.
Can you remind us how it was that Judge Peterson knew that Judge Emerson sent a letter to the Board of Commissioners saying you should not grant this budget increase? I mean, it was a public letter.
I think he copied her on it. I think he actually copied her on that. Please don't
be a way she learned about it. Okay.
I don't hold me to that, but it's, I think the letter's in there, but I think he copied her on that.
it was really very different from that attorney who sent one because Judge Peterson has told us, I had no
Right.
idea that ever happened.
Right.
Clearly Judge Emerson, she knew about, and I was wondering how they moved in different channels.
I think he copied her on it, but I'm not 100% sure about that. Then she takes office, and on literally the very first day, and I listened to Judge Peterson say, well, I really wasn't celebrated. And I think that's sort of a nice way of saying, yeah, I got sworn in, and then they were swearing at me before I ever really had a chance to settle into my office. And hot on the trail of that, and as those of you who have dealt with the investigative panel before know, you can get invited in. So she gets invited in. It was not a good meeting. I've seen the transcript of it. I was not representing her at that time. And then by the time I get involved in it, they filed a motion to interim suspend her with Supreme Court. We fought that and we won. It continues on. They file a second motion with the Supreme Court. We fought that. We won. And that's the one in which the Supreme Court said, and I vividly remember putting in the brief because I was trying not to be too snarky, but with all due respect, it's time to put up or shut up and let's have a trial or not. And so the Supreme Court said, yes, let's have a trial. We finally had that here today. And so what are we here about today? I don't want to get in the business of claiming that there's some cabal out there out to get somebody, but I do know how you might feel if you had 50 counts filed against you. 50 counts that was purposefully put out like that, filed in the public domain, and which Fox 5 was running investigative reports on all the time. I actually responded to some interviews, and the first question ever is, this is 50 counts. There's no judge in the history of American jurisprudence that had 50 counts. And yet we stand here today after 2 attempts to remove her from the bench, and 20 or more of those 50 counts have been dismissed or withdrawn by the Judicial Qualifications Commission. So, a fair question. Raymond Donovan is not known for a lot. He was Reagan's labor secretary, but he's the guy that famously said, where did I go? Which office do I go to get my reputation back? So you've been notoriously, given 50 counts, put out there in the press, and now, we're going to take 20 of those back.
Mr. Tate, I'm going to ask you a question.
Sure.
I'm going to put you on the spot because you are a former chair of the JQC.
I am.
You are intimately familiar with the rules and the canons. So of the remaining however many counts, are you telling us that on this evidence, there are absolutely no violations of the judicial canon?
No, I have a friend who is a pharmacist by training, and he said the joke amongst pharmacists is you can't open the door to the pharmacy without breaking the law. And it's probably true of most judges that you can't open the door to your chamber, without running afoul of some of those. And if you ask me as a former chair of the JQC, are there things that I think my client should have done differently or should have done better? The answer to that's yes. The answer to that's yes. No question about that. I do think, though, that the things that she has run afoul of have been mostly minor things, misdemeanors, if you will.
Very candid in admitting a couple of things.
Yes.
Things of the head or the heart or both or neither.
Yes.
What do we do with that?
Well, I think there's a couple of things to consider there, both of which come from our judicial authority, the Supreme Court. Because when I look at the remaining 50 counts, and I'm not forgetting your question, Commissioner Hyde, but I want to try to frame it in an answer to him. And that is that there are basically 3 sets of issues here. There's what I would call non-judicial conduct. It happens while the person is a judge, but is not related to their work as a judge.
Yes.
Right. And then there's judicial conduct, which concerns ruling, holding somebody in contempt, what you do with a year's support application, letters of administration, those are rulings. And then there are other things that I don't know quite where to put. They probably straddle that in this case. The wedding, marrying somebody is is something a judge can do, but preacher can do it too. So reviewing public documents, a probate judge has that issue. There are allegations about that. It relates to her office. And then the email to Judge Emerson about the IT and where she finally kind of lost it, with him. That wasn't a ruling. She didn't hold Judge Emerson in contempt, but expressed contempt, if you will, in an email. So what I want to do is talk about the standards that I think would apply, to both of those. And I'm going to start with the ones that are judicial. And so there's a case, and I'm intimately familiar with it because it was when I was chair, where we defended, Commissioner Hyde is familiar with it, has to do with advisory opinions, but the Supreme Court spoke extensively about what legal error amounts to judicial conduct. And I paraphrase that case, by the way, is NRA Judicial Qualifications Commission Formal Advisory Opinion 239. And they basically say legal error only amounts to judicial misconduct if a reasonably prudent and competent judge would consider that conduct obviously and seriously wrong in all circumstances. But not every error of law, even one that such a reasonable judge might avoid making, warrants discipline. And that's to answer your question about this. Absent bad faith, errors in judicial discernment and application of the law implicate Canon 2A, which is what she's been charged under for many of these, only to the extent the pertinent law is clear and well settled. So I want to quickly apply these things to the three things that we're talking about here. The first is the question of the contempt. That concerns me. It concerned me greatly when I was a commission chair, when somebody got locked up that really probably shouldn't have locked up. And that's one of the things, Commissioner Hyde, that I think she said, I'd do that differently now. And it is. And when I represent clients that are judges, I say, please talk to me before you hold somebody in contempt. I probably have the only two judges here who've done contempt right, but I once said to Chief Justice Boggs on a panel, there's probably not a lawyer in Georgia that really knows how to do it in every circumstance. So let's talk about the facts of this circumstance. You have a person that's coming forward with some type of immigration motive that's been expressed there, that's clearly put wrong information on the marriage license when she got the marriage license and now wants to change it. Again, I would say to you, I don't think she should have been held in contempt, but there is a basis upon which for direct contempt, something that's within the presence of the judge can hold a summary proceeding about. If it's not within the direct presence of the judge, then it's subject to being referred out for another judge to hear that case. But the law on presenting documents like that, I don't think is clear and well settled. Was it wise? Absolutely not.
How about giving a party the opportunity to consult with counsel before sending them to jail? Is that well settled?
I think it is.
Especially for someone who's a former prosecutor and worked in the criminal realm, right?
I think that the role of counsel, I think you made the point. You appointed counsel in the civil case, which I don't think there's anything wrong with it. Why didn't you use some money?
Which was a little, again, hard to process.
That's correct.
So quick to appoint counsel in a civil case and less quick to do so in a criminal one.
Focusing on the jailing, at least for the time I think you have.
Mhm.
I need to hear about that. That's the biggest deal to me.
It's the biggest deal to me. And I think that if that happened now, Judge Peterson would not undertake that. I think what Judge Peterson would do, and I think what her testimony that she would do, is to refer it over to the DA's office and let them let them take a look at it.
So I'll come back to what do we do, but what do you think, former chairman, is the appropriate sanction for the admitted conduct today?
Well, I think the appropriate sanction would be to make sure that she is fully aware of fully educated in the types of contempt,
So
training to be fully trained with the types of contempt. And there are, according to you all's rules, restrictions that can be placed on what a judge can do, what types of case they take, and that type of thing. And so I think a subject restriction that said, you don't have the power to hold anybody in contempt, because she doesn't really have to put anybody in jail, has no traffic jurisdiction, nothing like that. But you can cite them.
when I said outside the box, maybe if she wants to hold somebody in contempt, you consider that it has to be approved by a Superior Court judge.
Exactly. No, I think that's fair. I think that's fair game. And you know, many times a judge will cite somebody for contempt, but then the actual hearing is held by somebody else. So I think that's there. With regard to, I was going to move on to the year's support. So with regard to the year's support, it was within her power to appoint someone. The service issues she testified about, I think, gave her the discretion to do that. And you will recall that what they did was she extended a deadline. And understand, lawyers are not happy when the deadline pops up and the judge extends it. But in that instance, that year's support was going to set aside the whole estate. So there was a lot in the balance, and she made sure that a pro se litigant had the opportunity to be heard. It ultimately went up to Judge McLean, and Judge McLean.
Sorry, is the record clear that Judge Peterson knew that the year's support would wipe out the estate? I'm not disagreeing that may be factually correct, that a year's support was $52,000 and the estate was $50,000. But
I know it was a smaller, I don't want to, maybe not clear. I know it was a smaller estate. And typically with smaller estates, you're trying to set the whole estate aside to protect it from creditors and to.
But it's probably in the pleadings, but would part of the pleadings be, we believe the year's support is $40,000, the size of the estate is 30. So Judge Peterson simply had to look at page 2 of the pleading, and she could see, this is one where if I grant it, there is no more estate.
I can't answer that. Well, I think there is some testimony in the record, but I'd have to go back and look at it. So I'm going to move on quickly to the administration of the estate. All I'm going to say is that 2 things about that. One, the administration of the estate was less than 60 days delayed in the middle of COVID, in the middle of her first year in office when they are shorthanded. There was no dispute that the order was signed on the 18th. Absolutely no testimony about that any other time. With the backdating, we went through an extensive dance with the JQC for them to interview her employees without her present. And when they interviewed the employees without her present, they said, we were taught about the backdating before. Judge Peterson didn't know anything about it. She corrected us when that happened. So that covers the judicial situation. The Rose Bar, all of the social media postings, all of the homeowners town hall stuff is non-judicial stuff. And for the non-judicial stuff, the Coomer case says longstanding precedent makes it clear that although actions taken in a judicial capacity, acting as a judge, not merely while a judge, can warrant discipline, regardless of good faith. Actions taken outside a judicial capacity can warrant discipline only when taken in bad faith. These social media postings, and you'll hear more about that and have seen more about that in the First Amendment grounds that we have raised. But these social media postings were in no way ever tied to, I'm going to get a better deal in court, if I go down to the Rose Bar. it was, you had, used your name as a judge. By the way, I think all of them were prior to her being a judge. She may technically fall under the judicial candidate. With regard to the,
Looks like,
I do agree. But I also want the panel to understand what this public that's testified in this courtroom says, which is, I thought that was too provocative. And so that is a far cry from, this shows me that Judge Peterson is on the take, some way. And the people that are filing this, and I said this in opening, I said, what they're offended by is not what she said, but by the fact that that she was a judge, that she was the new judge. And you heard Miss Stephanie Williams that testified yesterday and said, I'm nosy, and indicated, oh, this just wasn't judgy, it didn't look judgy to me. And then you heard the testimony from the lawyer yesterday about the administration, who said, yeah, I had written the letter before. I'd written a letter to the county commissioner myself about this beforehand. These are not just members of the general public that looks bad to. These are people that are looking around actively for something. I'm nosy that way, was what her testimony was.
The posting about come see me, meaning Judge Peterson, in this play, and here's a discount for tickets you have to pay for. That's 404B. That's not one of the counts. Is that correct?
I think that's correct.
In office, because part of the issue was this advertisement for a private play was on a probate court website, but that's for us, we'll call it educational purposes. That's not one of the counts.
That is not one of the counts. And I would also note, though, with regard to that and the college homeless sexual, play video, though, there are lots of things that get reported. I'm not going to put these up on the thing, but I've got stories that Bill Rankin at the Atlanta Journal-Constitution wrote about the Bard Show, and about the Bard Show was raising money for cancer because the sponsor of the Bard Show, the producer of it for many years, had passed away because of cancer. Here, what we have is, in my view, a far less reputable. We got a Facebook news site that's taking her stuff, and putting it out there. So none of this, I think what I said, I think I quoted the Spoon River anthology, a picker of rags and the rubbish of spites and wrongs. And these were things that people were looking for. I've got about 10 more minutes. I want to answer all your questions, but I want to go ahead and talk for just a minute about the wedding and about the review of the public documents in the email. I've already sort of touched on the email to Judge Emerson. So when I specifically say this because you, Judge McBurney, said, oh, when Sheriff Pounds testified, I think he denied that conversation. There's some conflict there. And I simply wanted to remind you of of my cross-examination of him, or what he testified to. And I first asked him, so you weren't aware they were, this is on page 1067, you weren't aware that they were doing after-hours weddings at all, talking about his deputies, all right? Correct. So when Judge Peterson called you that day and she told you that Clayton was down there, right? She did, yes, sir. And you said, well, he's security, didn't you? If the pastor deputy is down there, he's security, correct? And his answer was, yes, he is security, but not by himself. And I said, well, I guess what I'm saying is, if you don't know they were performing weddings down there and you thought they were down there, then you probably thought he was down there for security purposes because you didn't know he was doing weddings. And he said, no, sir, I didn't know any of that at all for whatever reason. And I said, so if Judge Peterson told you that the pastor deputy was down there, you would have replied, if the pastor deputy is down there, he is security because you didn't know anything about him doing weddings, right? And he said, that could be true. I don't recall. I asked him later about the letter that she sent. And I said, this is a letter that she sent. He says, yes, sir. And it's written after you restored her security, after hours access. Yes, sir. And you never replied to the letter or said anything about it. He said, I don't recall. And I said, and in this letter, she says, when I spoke with you personally on Saturday, you advised that the courthouse was secure when I was there because the pastor deputy was there and he is security. Did you see that? Yes. And I said, and that's what you just said. You may have said, you just didn't remember, correct? Answer, yes, sir. So that is not unequivocal testimony or, in my view, clear and convincing evidence of some disregard. Besides, I'd be remiss if I didn't say the deputies that were down there went in and left the doors standing wide open. And that was nothing to do with her. These deputies had performed 30 or more weddings, I think the testimony was, and nobody even knew it was going on. But with her, they cut her courthouse access off the first time. The second thing is the review of the public documents. I don't think, the JQC goes out there, they flash their badge, they ask for these things, but I think the testimony from the entire staff, and Judge Peterson wasn't there, they weren't denied to review public records. They couldn't find the public record that they wanted. They didn't know how to locate that. And in fact, they didn't even, there was a sort of disconnect between the witness that testified today and the JQC, because even though she was at the wedding, they're asking for a date. So they never actually hooked up which was which. And then the last thing that I will go back to very briefly is the email from the email to Judge Emerson. And it was not a model of professionalism, but I don't know a lawyer or a judge anywhere that has not sent an email in modern times, or maybe a letter, or said things on the telephone that they should not have said. And a lot of this is brought on because it is the culmination of what the sort of culture there with Judge Emerson, who is, and he testified, when I cross-examined him, he testified, I don't know anything about probate court. I don't do probate court. I don't know anything about it, but I feel qualified to write a letter to the county commission about what you're doing over there. And so I asked him this question that, so is it fair to say that from the time Judge Peterson was elected through the first 3 months of her term of office, the only interaction you had with her was to write a letter to the county commission saying she didn't deserve a raise, file a complaint against her with the Judicial Qualification Commission, which, by the way, on this form says, what's your interest in it? None, absolutely none. He was on Fox 5, or was quoted on Fox 5 in all these other attacks. So what we have here is a judge that is far from perfect, but who staff members have repeatedly said is smart as a whip, is changed things in the office, put in a new computer system, tried to improve things, has strove and fallen short sometimes, but has continued to go and try to do that job as a probate judge. And it did so at a time too, where they were moving into an Article 6 court, which was a different situation for them. And it's been at a time of political controversy in Douglas County for a lot of reasons, because things are changing in Douglas County. So in closing, the law requires that she get the benefit of the doubt, I guess, clear and convincing evidence on this. But I would respectfully submit to you that the ways in which Judge Peterson has fallen short, she has expressed a willingness to move forward with, and you heard the questions today about, you've been to every training, you've gone to try to learn to do more. You heard how she's reached out to other judges about this kind of thing. this is not a judge that, in my view, even come close to somebody that you would remove from the bench. But that has been the cry of the Judicial Qualifications Committee, IP, not the hearing panel, but the investigative panel, since the very beginning. 2 motions to remove her on an interim basis on a paper trial without even a real trial. And so, you know, when you're a judge or a trial lawyer, you've got to put on your armor and you've got to have a little bit thicker skin. And I realize that. And I think she would tell you, has told you, she probably needed to have a little thicker skin about some of this. But we ask you to dismiss these charges that are not appropriate. And if there are some that you feel are appropriate, I've tried to address that as to how I believe it's within your power to fashion that remedy. Happy to take questions.
At the risk of expanding this discussion.
Well, I did my 30 minutes. I moved quick, but I'm happy. It's your time now, and I'm happy to do whatever you want to do.
You started your presentation today by saying that you were going to give us the big picture, and that's what I like to look into. So I'm looking at the evidence as a whole, not into isolated slices, but it paints a picture to me which concerns me about Judge Peterson's demeanor, right? So we've got several examples here, which at least with the evidence that we have paints a picture of a pattern. We have the contempt hearing. Perhaps she loses her cool, little short fused jail time. We have, you know, a fight with IT members in Douglas County, which leads to an email that says intent to sue. I'm going to sue you. I've got some testimony or some evidence here about a video showing sort of a public shouting match in HOA meeting where she's essentially shouting out to the board, you know, have elections and we'll dismiss this lawsuit. And that's kind of in a public place, and we've got that on video. And lastly, I've got this email, which, you know, it is seemingly, given the previous email, the email she's responding to is a massive overreaction. And some very strongly worded language that's disrespectful to Judge Emerson. And I understand that there's a history there, but I'm looking at the email response to the email he sent. But in a larger picture, it raises lots of questions in my eyes about the demeanor of Judge Peterson. And, you know, these are just the instances before, and certainly these could be the only 4 times this has ever happened. But witness after witness testified to being, you know, we had an IT guy who was basically afraid of her. So I want you to speak a little bit about that and tell me why this is not a pattern and why this shouldn't be as concerning as I think it is.
Absolutely.
And how do we remedy that if it is remediable?
I'm happy to do that. I want to make one brief preface about this. I fully accept the premise of your question. I want to answer your question. We have also had people who were putting her under the microscope here, and they were looking for those. So when you see a pattern, it pops back up. And you know, with the
but judges are hired.
Absolutely. So I'm pointing that out, but I'm not.
I'm going to add it as sort of example 5 of demeanor, which is
It's
everyone else and it's not me. I'm under attack by everyone. Everyone's out to get me. Obstacles, conspiracy. We must have heard the word obstacles 50 times during the original testimony.
We don't have judicial conscription. You applied for the job.
Exactly.
And so
concerned
that the problems are always outside of my space being inflicted upon me, as opposed to maybe perhaps being the byproduct of something that you are doing.
Okay, so I accept all that criticism. I accept that you can connect the dots between that. And I would also say that there have been judges that have had these problems since time immemorial. And all of us lawyers, and Mr. Hyde too, have probably appeared in front of some of those judges, you know, from time to time. And it has been dealt with by the Judicial Qualifications Commission. And I want to say, you know, I was the chair, but you asked me about that. I'm not trying to be some kind of am expert witness
Oh,
about
understood.
this. Please don't take it that way. But I've represented judges that have lost their cool on the bench, and the commission, as a sanction agreed to or otherwise, has said, you need to go to an anger management class, or you need to go seek some kind of support, for that before. We have had judges, particularly in, I'll say non-trial court, judges, that we have said, go spend some time with another judge. And we did that for a long time. Mr. Hyde will remember with magistrate court judges. I'm not sure we sent them to the right place, given some subsequent things that happened. But you have also heard at the same time Judge Peterson say how she had a mentor and how she called that mentor and how she, how she used that. And I would also say that I think having a mentor that has dealt with the same kind of problems you've dealt with is probably more helpful than somebody that has not. A white male of my age might not be as helpful to Judge Peterson as would a woman who has dealt with some of those issues before and how is best to react to that. But there are seminars and options, and there are support groups out there. One of the groups that I've been involved with, the American Board of Trial Advocates, has a program called Trial by Women, and it's for women to talk about those kind of things. So there are things out there that I think could meet that concern, which are not disciplinary things per se, but aids and help. And that's been a consistent thing that she's talked about is, I wanted some help, not some obstacles, to be
the first to say after doing the commission's work for almost 20 years, to do a lousy job educating judges, particularly new judges. What I can't get around is that she took somebody's freedom away from them for 2 days. That person can't get those 2 days back. Doesn't matter what their station in life is or is not. So that's my struggle.
I understand that.
Unlawfully, if we had a trooper in South Georgia that picked up a drunk driver, put him in a jail cell for 2 days with no authority, we would not be handled. So that trooper would be fired and sent to federal prison.
There would be some reaction to that. I don't know that qualified immunity would.
Let's get in a closet. I mean, taking somebody's freedom away is next to the death penalty. The worst thing the government can do to somebody.
I understand your concern about that, and
that's my struggle.
I understand your concern about it, and I've suggested some ways that I think that can. So I think what I'm asking, and I'm not trying to cut y'all off for questions or whatever else, but if I come back sort of full circle to some of the questions you asked, I think there are tools in the toolkit of the JQC rules when it comes to if you find there's a violation, here are the various things you can do that are not purely punitive in nature, but which help her become a better judge. And I would ask you to apply those. Are there other questions? I just want to thank you again. The trials run very smoothly, and I appreciate all you've done. Thank you.
I would like to also extend thanks. I don't know that there's anyone here other than our bailiff, to the good folks of Cobb Superior Court for making this space and the safety of this space and all of the technical facilities available for so many days so that we could get through all this. So I'll send something to Mr. Hansard, who's the court administrator, on behalf of all of us. An email would be something. But this has been a good place to do what we needed to do in connection with all this. Also, thank you to counsel on both sides. This has been a long process, but we know up here that you all have stayed focused on trying to distill for us the essence of what you're advocating for and against and whatnot. So thank you for your time as well. I will circle back with the lawyers after I talk with my colleagues about next steps. That will include a deadline for the director to respond to the directed verdict motion, the written one. And then we'll map out what type of oral argument schedule. It sounds like counsel on both sides are open to it being virtual. We'll probably set it up so it can be in person for those who want to be in person or who can, but there'll be that virtual option in case one of the panel members can only connect virtually, or that's what makes sense because Judge Peterson's got court that day or who knows what. But it'll probably be a hybrid setting, no mandatory in-person appearance, but we won't need to rely on this good space to pull that off. Okay. Ms. Veal, anything else on behalf of the director?
No, Your Honor.
All right, thank you. And Mr. Tate?
No, Your Honor.
All right, thank you, everyone. Yeah, you do. He'll come back. Okay.